Through online, I'll do this matter.
Which matter?
119. Today it is not possible. Through online, I'll do this matter.
No difficulty. You can.
Deep.
Yes.
Same. Your Lordship, application for inclusion, Your Lordship.
What is the application?
Your Lordship, there was a direction on the respondent to file affidavit, Your Lordship, in opposition, Your Lordship, but it has not been filed, and eventually the bank account has been attached, Your Lordship. This is a GST matter, Your Lordship, and so the petitioner has preferred an application, Your Lordship, stating the facts, Your Lordship. Grateful, Your Lordship.
Look, my lord, this is for,
Please do not mention hearing matters because lot of matters have
my
been
lord, this is
listed
for
already.
correction of the cost title, my lord.
Yes,
My
correction.
lordship, this is a registration matter. And my lord,
Yes.
there was a direction passed on 2nd of May 2023 to file affidavits to the respondents, to the entire respondents, my lord.
That has not been filed as
No.
yet. So please wait.
My lord, it is being
Anytime, my lord. I'm offering my lord one.
It's a hearing matter.
My lord, it will
See
be
the
listed as to be
list, sir.
mentioned, my lord.
I'm hearing out matters.
My lord.
So I should get time. Let me see.
My lord, please, any day, anytime, my lord.
It has been fixed already, but I.
In the list, but that is not fixed. My lord, if kindly, but this is, I have debarred from participating in any tender. Upon me, 114.
Even if I fix a day, what difference will it make, sir? Because I have to reach,
My lord,
isn't it?
my lord.
It is in 119, I fix Monday, but I have to reach 119 even on Monday. So it will not make a difference. Please wait, let me see if I can reach. So many
Lordship.
motions, what can I do, sir? I have to dispose them off.
My lordship,
And I take them up serially. You've seen, I don't break the serial.
The difficulty is the motion is coming in the past, the hearing will not be done in any way. On the last circuit, that was also happened. my
It
lord.
is happening in all the
It is
circuits.
happening
We
in the
have to
circuit,
think
so
over.
The advocates have mentioned this matter before the
We have
past
to
day,
think
31st
about
in the
this.
meeting with the milots. And in that meeting, that was fixed that a Thursday will be fixed for the hearing. All the advocates know that milot.
We have not been informed. I do not know. We have not been informed actually. I'll think over. Because something has to be done. Hearing matters are not being taken up at all. I know. I can
We have
understand
the
the
hope that is
difficulty.
on the 31st, that was the meeting is that it be
31st of,
31st of this, there's a first day of this.
it was not stated at all. You were not present in the meeting.
I am not present, my junior was present.
But this issue was not taken up at all. This issue was actually not taken up. I am hearing it for the first time from you. I'm hearing this for the first time.
It was proposed, others are there.
31st May, it was not even proposed.
It was not fixed. There was only the proposal, one day can be fixed for the hearing matters, but it was not finalized.
That is in the civil, in the appellate, in the revision, the division bench
yes.
hearings.
Lordship, may I be permitted for correction, Lordship? My lordship,
To be mentioned, correction.
lordship,
You have stated the WPA number with it?
Lordship, may I
No, nothing can be done. You have to wait for 1:30 to come.
Lordship, may I
My
permit?
Yes, my lordship. Content matter. After content note করে কাজ। You're mentioning only one content matter today, isn't it? What is the other WPA that you're mentioning? 158?
My Lordship, that is leave petition.
That is in the list?
No, my Lordship.
It is a hearing matter?
Yes, my Lord.
Affidavits are exchanged?
Yes, my Lordship.
Hearing matters will not be included now. Let me reduce the hearing matters. And unnecessarily no
Okay,
use
my
here,
lordship.
including here, okay?
Uh,
Let the content be included.
Lordship,
My
may I
lordship-
permit to mention one matter for correction, Lordship?
Yes, yes. To be
my
mentioned,
lordship, with
correction.
the permission of, I would like to mention one thing. You are directed to file a supplementary affidavit. We have already filed the same.
You want it to appear in the list? It's a motion matter. Give the number. Mr. Ghosh?
Two matters for inclusion, adjourn motions. And one for correction of. name.
What is happening is I cannot take up hearing matters for these motions.
If I may, subject to Millard's convenience, Millard, sometimes in the next week, if Millard gives priority to the hearing matters.
Motions cannot be taken up at all. You have to keep that in mind.
Millard, just
If
one-
you agree, I'll do that.
If Millard one For 1 day, my lord, if that can be done, subject to my lord's consideration. That's-
1 day hearing, will it help really?
My lord, it
Can
can
it
be
be
done,
concluded?
my lord, it can be done the first half for the motion and the second half for the hearing, my lord. There is so that
Whatever my lord decides in the
it can
next
be
week, so that, my
distributed.
lord, at least my lord, even if 3 matters are taken up, that
It
is my
will-
lord a lot.
Yes, I'll just consider. Next week I'll just consider.
Grateful. my lord.
Lordship, Lordship mentioning of one matter to be listed as hearing, my lord.
Yes,
Well, it was heard by your lordship in the previous bench, my lord. Thereafter, my lord, Justice Krishna Rao, my lord, the order was passed that the next circuit, this matter to become, my lord. Thereafter, my lord, Justice Sogoto Bhattacharya said, the matter did not reach, my lord. So, my lord, next week, anytime, my lord, not this week, my lord, as because it has fallen from your lordship yesterday that no mentioning matter as regards to the hearing to be mentioned. my lord.
please wait for the next week. Let me see.
Next
I have
week.
to take the other matters. They are
My lord,
already in the
my lord,
list.
I'll be moving out today itself, my lord. Next week, that is why I'm mentioning that not this week, next week, any day it will be listed.
I have not taken the hearing matters in the list. So please, sir,
My lord,
there's a very long hearing list.
my lord.
So unnecessarily increasing the list will not really help, isn't it? I need
Grateful,
to
Lordship.
take up the matters.
Yep.
Yes.
My lord, liberty to
anyone?
mention, my lord.
Yes.
My lord, I am mentioning for serial number 2 and 3, my lord.
Yes.
In the first matter, my lord, the matter was taken up in the last circuit bench where an interim order was given to the petitioner. The interim order has expired on the 31st of July, my lord. And the matter has not been listed in this circuit bench even for once. My lord, kindly enlist this matter on Monday, my lord.
Is it at
My
the
lord, my
motion
interim
stage?
order has.
Is it
Yes,
at the
my
motion
lord.
stage?
Indeed, my. Yes, my lord. It is in the motion stage, my lord.
Item number
Kindly
two,
listed as a.
Item number 2. And what about 3?
My lord, item number 3, the petitioner is a cancer patient, my lord. The matter was filed in the month of June, and not
Yes.
even once the matter was heard or enlisted in the previous 2 circuit bench, my lord. My lord, kindly appreciate the predicament of the petitioner and enlist this matter on Monday.
Yes, I'll list them. I'll list them.
Grateful, my lord. Grateful.
Didi? Monday.
My lord, may I permit to mention, my lord, on hearing matter, my lord.
Hearing
But,
matters, please do not mention. You've seen the list of hearing matters. So will it really help listing the matters unnecessarily?
Well, there's a direction that Behutta Justice Honorable Justice Singupta my lord, the matter will be appear the next circuit to second day of next circuit. But last circuit, the matter was not listed, my lord.
So after that, several circuits have gone by.
No, my lord, this is the one circuit was
Maybe so that order becomes infructuous.
last circuit, my lord.
That direction becomes infructuous. Last circuit you did not mention.
I mentioned, my lord, but
It
does
did not come up.
come up.
Please wait for the next week. Let me see what I can do with the hearing matters.
Great.
It's of no use listing hearing matters unnecessarily. Yes. No other e-mentioning? Days list. Yes, what is the correction?
Yes, my lord, my name and Mr. Ghosh's name will be.
Not included.
Yes.
Inadvertent error has crept into the order passed on 31st July 2023. Paragraph in the cause title of the said order, the names of be recorded as learned counsels for the state. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 31st July 2023. Urgent certified website copy.
Item 2 also the similar case, my lord, my name and.
Same order, order date to be given. Same order.
Yes.
Copy card order date to be given. Yes, next.
Same, ma'am, for the petitions.
Respondents,
I've
You're
got
appearing?
Number 6, 4, 6 and 7.
what is the application about? Oh, restoration.
Restoration application, lordship.
Within time?
Yeah.
Within
Not
time?
within time, lordship.
You were supposed to come back with a condonation application today.
Yes, lordship, that has been already filed yesterday, that is can 2.
Where is the application? It has not come up. Did the issue condonation book? Can wait a minute, what can one tablets? Yes, let it be allowed. Restoration. Can 2 of 2023. The petitioner prays for condonation of the delay in filing the restoration application. Paragraph, good grounds being shown, comma, the application is allowed. Paragraph, delay in filing the condemnation application is condoned. A delay in filing the restoration application is condoned. Condoned. Can 2 of 2023 is disposed of. Paragraph 4. Can 1 of 2023, this is an application for restoration of the writ petition by setting aside the order dated 2nd May 2023, dismissing the writ petition on petition for default. Paragraph, sufficient grounds being made out, paragraph being made out, comma, the application is allowed. Paragraph, the order passed on 2nd May 2023 is set aside. Paragraph, the writ petition be restored to its original file and number. Can 1 of 2023 is disposed of. Can we deal with the writ petition now? Are you ready?
I am ready.
I am not ready.
Not ready?
Lordship, then matter is urgent if it can be fixed
Yes,
next week.
it will appear in the list. Next week, very well. WPA order, let the matter appear under the heading motion on 10th August.
Grateful, Lordship.
Next. Petitioner. Petitioner. No one.
Mala, I am appearing in item number 4.
Yes, yes.
Item number 4. Yesterday, Lordship heard the matter. The state has
The state was not served, the state was not served, Millard had fixed today for orders.
That school service commission, the DI referred the transfer the petitioner to the Central School Service Commission. He is sitting tight from November 2022. Let him pass an order, Millard, appropriate order, because this honorable court already directed for taking steps for transfer of the petition in the earlier round of
The
petition.
representation has not been considered as yet. Mr.
Not
Ghosh.
representation, it is forwarded by
No
the DI.
representation is being
Lordship
made as
deputy.
such. It is only their
Yes,
application
has
which
been-
was forwarded to the School Service Commission.
No, in an earlier order, page 22,
Well, that was upon the
Yeah.
DI. The direction was upon the DI. DI considered the representation and passed an order which is at page 25.
I'm grateful to my learned friend. That order of DI, my lord, is a positive way that it should be transferred. And that has been recommended to
what
the
is the next
Commissioner of
step to
School
be
Education
taken?
The School Service Commission
only
now
for
will
issuance of the order
consider
of transfer.
an application for transfer and pass an order of transfer or reject the
So this
application.
has been forwarded to the school.
No question of
service commission.
rejection.
Yes,
When it is
yes.
recommended, you have to
This-
pass an order of transfer.
This
Law
was
does
not
not prefer
subsequently
permitted rejection.
subsequently transmitted to the School Service Commission. Now School Service Commission has to take a
So
decision.
it is before the school service commission
School
now.
Service Commission.
Yes,
So
my lord.
direction, so that school service commission disposes.
Takes a
it off.
decision, yes.
Regarding the transfer of the petitioner, kindly
Yes, yes,
mention that.
absolutely.
Obliged to lordship.
Today you're audible, absolutely, clear.
Grateful to your lordship. Well, that will appear at page 27, 7th of November, it was sent by the DI to the School Service Commission. At the
Yes.
top, my lord, the date.
Yes, yes, yes. Pursuant to an order passed by a coordinate bench of this court on 14th July 2022 in WPA 1843 of 2021, comma, 2021, comma, देना. Directing the
DI Kuch Bihar.
district inspector of schools within bracket SE bracket closed, comma, Kuch Bihar to dispose of to take a decision on the representation submitted by the petitioner on September 29, 2021.
And to pass a result order.
Seeking transfer. Stop. pursuant to the issue corresponding, comma, seeking transfer, comma, the District Inspector of Schools considered the representation and by an order passed on 30th August 2022, comma, recommended
To the Commissioner of School Education, my lord.
recommended the petitioner's prayer for transfer and sent the matter to the
West Bengal CSC, Central School Service Commission.
second respondent,
Yes,
second
my lord, second
respondent
this. My lord.
to
my
the
lord.
West Bengal Central School Service Commission, comma, being the second respondent herein for taking necessary decision thereon. Paragraph. Learned
Same
counsel
was sent on 7th November. Kindly, my lord.
decision sent to the second respondent therein বললাম না, ওখানে on sent on
7th November
7th
2022.
November 2022 for taking necessary decision thereon. Paragraph. Learned counsel for the petitioner submits that no decision has been taken by the second respondent till date.
No
Learned
transfer order has been issued, my
The
lord. He is not a
petition-
decision
the
taken by the DI.
The petitioner
He is
seeks
only the, my lord, he is to
a
only
direction
the
upon the second
issue an order of transfer.
to issue transfer order in favor of the petitioner in terms of the recommendation made by the District Inspector of
Inspector.
Schools, comma, being the fifth respondent herein. Hmm. The petitioner seeks a direction. Till date, therefore the petitioner seeks a direction upon the second respondent. What are the complete sentence? Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, comma, the writ petition is disposed of, directing the second respondent to issue necessary transfer order in favor of the petitioner in terms of the recommendation made by the fifth respondent in his order dated 30th August 2022. Within 2 weeks,
Yes, my lord.
Mr. Ghosh,
Yes, sir.
within 2 weeks from the date of communication of this order. Paragraph. The said order be communicated to the petitioner within a week thereof.
Grateful. All consequential steps should be taken. If we recommended, my lord, joining and other things, my lord, consequential
Yes,
steps
after
should
line
be
add
taken.
colon, all paragraph, all consequential steps be taken by the authority
On the basis of such recommendation.
following the order. Within another week, Mr. Ghosh,
Yes, my lord.
within
Yes,
1
sir.
week thereafter,
Within 1 week.
within 1 week thereafter. Next.
I'm for the petitioner also.
Grateful to your lordship. I am deeply obliged. Chalo.
Yes,
The petitioner is the school teacher, assistant,
have you served 7 and 8?
yes, lordship. All has been served and copy delivered.
Who is appearing for 7 and 8? Salsa Bari Model High School. You are for the other respondents. 1 to 6. They are served. Yes, please continue.
Also, the petitioner is the assistant school teacher who has who intends to persuade his higher education that is PhD before the North Bengal University in a particular subject. Within the scheme of the lordship, the service rules, since the service rules has envisaged a provision for the incumbent during his in-service period can pursue his higher education. Lordship, the petitioner had applied for the PhD course and he was selected and he was admitted in the particular program in the University of North Bengal. Now the school authority by issue a letter of accord or by a letter of recommendation, by an order dated 8th of January 2022 had accorded the petitioner to go ahead with his program. That is at page 25 of my application. First, kindly see. The express authorization that has been made. That authorization was made pursuant to a resolution. That is the next page, that 26. The resolution was taken on 10th of September 2022. So what happened? It appears from the subsequently when the petitioner had intended to attend his classes at the PhD, the school authority does not allow him to participate, to leave and to participate in the program in the PhD. This is the whole difficulty. That
But
the school authority
no
is saying-
objection is given by the school
Yes,
authority.
yes. School authority. Now what happened? The whole issue is that school authority has now subsequently telling to the petitioner that the problem is that the petitioner had given some impression that PhD course to be conducted through online. That's why they have accorded the petitioner to go ahead. But now they realize that the PhD program cannot be
Physically, right?
it should be done in physical mode. That's why the leave cannot be granted. This is the whole difficulty. Now, unless and until leave in true sense is allowed, the petitioner cannot pursue his program. So this is the whole difficulty. But there is no absolute dichotomy in the program of a online and offline program of PhD in the under the UGC. UGC only envisaged a particular program of PhD, only one mode of physical, that is physical mode.
Yes.
So this is there is no cleavage of online PhD and offline PhD. Now, subsequently, by impugned resolution that is at page 32 of my application, the school authority has taken a particular resolution. Kindly peruse the particular portion of the resolution.
Page?
That page 32. 32 of my application. Kindly see.
Yes.
The relevant portion I'm reading, Lordship. বিদ্যালয়ের সহকারী শিক্ষক প্রবীর দেবনাথ মহাশয় গত 7/9/2022 তারিখে নর্থ বেঙ্গল ইউনিভার্সিটিতে ফুল টাইম রেগুলার মোড পিএইচডি প্রোগ্রামে ভর্তি হয়েছেন। সে তার স্টাডি কন্টিনিউ করার জন্য অনারেবল প্রেসিডেন্ট ওয়েস্ট বেঙ্গল বোর্ড অফ সেকেন্ডারি এডুকেশনের নিকট আবেদন করেছেন। প্রবীর দেবনাথ মহাশয় তার আবেদনপত্রটি বিদ্যালয় প্রধানের নিকট জমা দেন। এই অবস্থায় তার এই আবেদনপত্রটি মাননীয় ডিআই স্কুল আলিপুরদুয়ার মহাশয়ের নিকট পরবর্তী পদক্ষেপের গ্রহণের জন্য জানিয়ে পাঠিয়ে দেওয়া হয়। আজকের সভায় সর্বসম্মতিক্রমে গৃহীত হলো। এই ব্যাপারে প্রধান শিক্ষক মহাশয়ের উপর কোনো রকম আলোচনা।
So it was only forwarded.
Now they are saying that if the leave is granted, then the school will be in problem to get the teacher.
Where is
That's
that
why-
stated? Where have they said so? You are seeking leave for what period? For how many months?
As per the regulation, Lordship, provision of law, Lordship, it is Rule 4, Sub-Rule 26. Now the impugned, Lordship, can first peruse impugned resolution. Impugned resolution at page 26.
of the writ petition.
of the writ petition.
Yes.
বিদ্যালয়ের সহকারী শিক্ষক প্রবীর দেবনাথ মহাশয় বিগত 8/1/2022 তারিখে বিদ্যালয়ের ইমেল মারফত এনরোলমেন্ট অফ পিএইচডি কোর্সের ওয়ার্ক অ্যান্ড ফলো আপ প্রোগ্রামের থ্রু অনলাইন পোর্টাল করার জন্য বিদ্যালয়ের এমসি এর নিকট এনওসি জানায়। অনলাইন পোর্টালের মাধ্যমে কোনো কাজে বিদ্যালয়ের স্বাভাবিক পঠন পাঠনে কোনো ব্যক্তি ব্যাঘাত ঘটবে না ধরে নিয়ে স্কুল ম্যানেজিং কমিটি শ্রী প্রবীর দেবনাথ মহাশয়কে এনওসি দেয়। এক্ষেত্রে কোনোভাবেই রেগুলার কোর্সের ওয়ার্কের উল্লেখ ছিল না। পরবর্তীকালে অন 14/7/2022 তারিখে সে জানায় যে 20/6/2022 তারিখে সিকিং স্যালারি রিলেটেড ইনফরমেশন ডিউরিং টেনিওর অফ allotted for the pursuing further higher studies on the subject ডিআই স্কুল যোগাযোগ করেন এবং এই সকল তথ্য কর্তৃপক্ষ গত 19/7/2022 তারিখে ডিআই স্কুল ফরওয়ার্ড করে। Now the relevant portion is at page at the relevant 1, 2, 3, 4 fourth paragraph. SMC মনে করে স্কুল ম্যানেজিং কমিটি মনে করে যে রেগুলার মোড কোর্স এর জয়েন করার অনুমতি দেওয়ার অধিকার এসএমসির নেই। তাই তার এই বিদ্যালয়ে অনুপস্থিতি বিদ্যালয়ের স্বাভাবিক পঠন পাঠনে ব্যাঘাত ঘটাবে। এই অবস্থায় তার অনুপস্থিতি কিভাবে কি হিসাবে গণ্য করা হবে তা মাননীয় প্রবীর দেবনাথ মহাশয়ের নিকট হতে লিখিত আকারে জানতে চাওয়া হচ্ছে। এসএমসিতে আরো সিদ্ধান্ত নেওয়া হলো যে আর এই অনুপস্থিতি জনিত কারণে কোনো সমস্যা হলে ভবিষ্যতে যদি কোন উদ্ভূত হয় তবে এসএমসি কোনোভাবেই দায়ী নেবে না। এই সিদ্ধান্তগুলি প্রবীর দেবনাথ মহাশয়কে ইমেল মারফত জানিয়ে দেওয়া হবে। এই সিদ্ধান্ত আজকে সবাই সর্বসম্মতিতে গৃহীত হলো। This is a peculiar thing because the authority has been vested with the power to take a decision, but the authority does not know how to take the decision.
Where is your application before the authority?
Application before the
Authority, they say that they thought it was online.
no online.
Where is
My
the application?
application is at page 29.
Yes.
Now the higher authority, that is Lordship, the Deputy Secretary, Government of West Bengal Board of Secondary Education, by a letter dated 11th of April 2023, that is at page number 48 of my application, has directed to take a decision. 48 of my application.
Yes. After
Now
the
the deputy-
resolution, they have forwarded your prayer
Now,
by a
forwarded my
subsequent,
prayer.
by a
Definitely.
subsequent
Yes, yes.
resolution.
But
Yes.
no specific resolution in terms of the provision of law has taken and communicated to me. Thereby, I am prejudiced because I am not in a position to take to participate in my program in PhD. The relevant provision is at is Rule 423.
Rule 423, yes.
Every teacher or non-teaching staff shall submit an application to the board for appearing in any examination through the district inspector schools or additional district inspector of schools of the concerned subdivision with an approval of the committee. The head of the institution shall allow a candidate to join on fresh appointment on or transfer in the post of assistant teacher
This
or
is a
non-teaching
different
staff.
issue. 24 is different from 23.
Sorry, 23.
23 is the relevant
Relevant portion.
provision, yes.
Yes, so with the approval of the committee, the approval has not yet been made in clear terms and categorical terms. This is the whole difficulty.
Here, the DI of schools will only forward the application to the board.
Yes.
Yes.
Hmm.
With approval of the committee. So
With
the committee has approved the forwarding, isn't it?
Approval is
So
to
now
be asked.
decision has to be taken by the board.
No, according to the provision,
Candices 30 and 31, well, that will clarify. Come on, 30 or 31 words. The board has made his point very clear. 31 would have a look at. 31 is the board.
This was sent to the board
Yes,
by the DI of schools.
yes, that is at 30.
Yes,
DI to board,
yes.
31 is board to DI.
This
Yes.
is 22/9 and
Yes, 21st
November.
November. As directed, this is to inform you that NOC to continue PhD course in favor of so and so may be granted by the competent authority after the application is approved by the managing committee and subsequently forwarded to and by the concerned DA as per rule so and so dated so and so.
And this approval has not been made.
No. But this will the managing committee has to approve. Now, the only difficulty which is standing on the way to my mind is probably Millard that PhD on a permanent basis, that is on offline mode, doesn't come within the meaning of deputation. B.Ed and DLED comes under the meaning of deputation. A teacher while drawing salary can be sent for studies on deputation. PhD does not
Where
fall
is
into
that
that
rule?
category. Millard, that is
There
Millard-
should be a specific rule to that effect.
Millard, our written instructions, DI has stated that, but this Millard, the managing committee has to communicate in writing. That
Yes,
this is the reason why they are
Yes.
withholding it, or if there is no reason, then they have to grant it.
they have made a very vague observation. There will be difficulty.
Yes, yes, yes.
That's a very vague observation and
Yes.
that cannot be in terms of any rules or laws.
Yes.
isn't it?
day before yesterday, Honorable Supreme Court in a very fresh matter, Lordship has taken a cognizance of a very pertinent issue that a time spent for PhD cannot be counted as teaching experience if it is not done along with the teaching assignment without taking leave. So the leave is very sine qua non. This is the Honorable Supreme Court judgment that has the matter is at motion stage. Notice has been issued.
The fact has to be seen.
No, absolutely,
Facts may be
absolutely. The
different.
law is very precise.
Law
That unless
pertains
and
to
until,
facts, isn't it?
unless and until I take a formal leave in terms of the law, within the terms of the scheme of the law, so my leave will be construed as a break of service. So I should not be allowed myself to take,
Leave is different from salary.
absolutely,
Leave may be with or without salary.
Absolutely.
Yes, you are asking for paid leave.
paid leave. Exactly.
Leave can be granted. There is
Yes.
no dispute.
No.
Whether the salary
Yes,
can be paid is in dispute.
Yes, yes.
Yes. Mr. Ghosh, do you seek to come back with a report then? You have the,
I don't represent the managing committee of the school. That is the difficulty.
no, you are for the DI of school.
I am for the DI of schools. DI of schools, not also the board, because board is represented by a different set of councils.
The school is not represented at all today
Yes, that is the difficulty.
because they need to take a call.
Then the lordship is interim direction may be passed upon the board and to come back on a date fixed. I will communicate the order.
Managing
complex.
committee.
Managing committee,
School, managing
school of
committee.
the managing committee be directed to take a decision in terms of the DI communication as well as the law, within the law.
That can
That
be
can
done.
be done.
That can be done without
Yes.
going into merits.
Without going into.
That can be done.
Yes.
Affidavit of service. None appears for the 7th and 8th respondents despite service. Paragraph. The petitioner is an assistant teacher of Salsalabari, S-A-L-S-A-L-A, Salsalabari Model High School and intends to pursue PhD program in biotechnology. Stop. the petitioner applied before the District Inspector of Schools, Alipurduar, on 20th June 2022,
No, Lordship,
seeking
I applied on
29, page 29.
The application, first application is 8th of January 2022.
Where is your
8th of
application?
January.
Where is it?
Application, that first application is not attached, Lordship. The first application is not
Have you
attached.
stated in your writ petition?
I have stated in my.
Oh, this is a leave application, is it?
Leave application, yes.
The petitioner, people have submitted for leave on 8th January 2022. Before the district, DI of schools to category. Applied for. The petitioner? And by an order passed on the same day, comma, the headmaster of the school issued a no objection in favor of the petitioner for pursuing the PhD program. Stop. The petitioner filed a subsequent, submitted a subsequent application before the District Inspector of Schools, Alipurduar, on 20th June 2022, seeking clarification about the government guidelines pertaining to receipt of monthly salary during the leave period, since the salary received from the profession was his only source of livelihood. Stop. By a resolution taken by the page 26 was taken
26
by
is the impute resolution dated 10th of September 2022.
by a resolution taken on 10th September 2022 by the managing committee.
Managing committee.
By
the
the
school.
managing committee of the school. Taken on data column, comma, the managing committee of the school.
Page 27. Fourth paragraph, fourth and fifth. Paragraph.
Held that the committee had no authority to recommend
The committee,
a regular mode of studies, since absence of the petitioner shall hamper the curriculum of the school. The committee further resolved that the committee would not be responsible for any problem which may arise
in the
due
event
to
of absence.
due to absence of the petitioner. The said resolution was forwarded to the DI of schools.
Yes.
was forwarded to the District Inspector of Schools by the committee stop. The District Inspector of Schools issued a letter to the President, West Bengal Board of Secondary Education on 22nd September 2022 enclosing the proceeding of the managing committee meeting dated 10 2022, informed that no objection certificate to continue PhD course by the petitioner may be granted by the competent authority after the application is approved by the managing committee and forwarded. What is this to and by? How can both come together?
To and by.
To and by the DI of
Yes,
schools.
Forwarded to and by the
It should be forwarded to the DI of schools.
Subsequently forwarded to one.
What is to and by?
The managing committee would probably had sent two communications. One was forwarded to the DI, then the DI has returned back to the managing committee, something of that sort. I don't know.
So let it be forwarded to the, shall I record only two then?
Yes,
Doesn't make any sense, to and by. To and by cannot be together.
No, cannot be.
Forwarded to the District Inspector of Schools. Schools as per rule 4 within bracket 23 of 4 within bracket 23 of 214 hyphen SE slash S slash 10 capital M hyphen 01 slash 18 dated 8th March 2018. Paragraph, learned counsel for the. This is your submission also,
Yes,
that
yes.
the managing committee should take a decision in
Should take
terms
a,
of
should,
this.
should
Yes.
take a decision.
Learned counsels for the
DI.
petitioner as well as the District Inspector of Schools submit that the seventh respondent, that the managing committee, being the seventh respondent herein, be directed to take a decision in terms of the letter issued by the West Bengal Board of Secondary Education. Paragraph, in view of the above, the writ petition is disposed of, directing
Proceed,
the,
may humble request, let the petition be keep pending, because that will be a problem.
that will be a fresh cause of action, sir, if it is not to, in your favor.
Now, if your direction is passed to them
In
to
this
comply,
petition cannot be disposed of, cannot be considered. If there is no compliance, you come up in contempt. If there is a compliance against
understood.
you, that's a separate cause of action.
understood,
So there is no question of keeping this pending. Yes,
understood.
no further relief can be granted here. In view of the above, paragraph, the writ petition is disposed of, directing the seven
Seventh and eighth,
respondent,
7 and 8,
seventh and eighth both.
7 and 8. Yes.
তাহলে এর আগে যেখানে 7 বললাম না, being the seventh respondent hearing, ওখানে add, হ্যাঁ? No, no, no. Being, and the, ওখানে add করুন, and the headmaster of the school, comma, being the eighth respondent, be directed. হ্যাঁ, তাহলে এখানে কোন directing the seventh and eighth respondents to take a reasoned decision in terms of the letter issued by the deputy
Unambiguous,
secretary.
isn't an unambiguous decision?
Yes,
Unambiguous, because
reasoned
they-
decision is always unambiguous. In terms of the letter issued by the deputy secretary within bracket academic bracket closed West Bengal Board of Secondary Education to the district inspector of schools, comma, Alipurduar on 21st November 2022. Within 2 weeks,
Yes.
within 2 weeks from the date of communication of this order,
also within the light of the provision of section 4 subsection 23 of the rules.
that is
West
stated
Bengal-
in the letter itself. I have said in terms of the letter,
Yes.
that is stated in the letter itself, and I have recorded that.
Relevant rules.
An opportunity of hearing should be given to you.
Yes.
Upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph, since the seventh and eighth respondents are not represented, comma, the petitioner is directed to serve a copy of this order along with a copy of the letter issued by the West Bengal Board of Secondary Education dated 21st November 2022 to the seventh and eighth respondents at the earliest.
Yes.
এর আগে একটা line করুন, the decision taken by the authority shall be communicated to the petitioner within a week thereof. এটার আগে। You can take this back.
Grateful.
Okay. Next,
Lordship, in item number 6, I am on behalf of the petitioner. The matter relates to interest on gratuity, Lordship.
your affidavit of service?
Yes,
I'm appealing, my lord, for this.
this is the affidavit of service, Lordship.
Affidavit.
Lordship, I have a drafted order also.
Single PPO,
No, Lordship, double PPO. and
revised?
Revised PPO under ROPA 2019.
The same order will be passed as passed in other matters.
Lordship, I have a drafted copy of the order.
My order?
No, Lordship, Justice Mantha's order,
Not
Lordship.
necessary. I have my own orders. I'll pass this.
Obliged, Lordship.
Revised
of-
PPO, note করুন, join the
Date of effect will be, Lordship, 14th February 2020.
Yes, yes.
It is disposed of then, my lord.
হ্যাঁ, ঠিক আছে। Revised PPO 14th February 2020 date of effect.
My lord, the matter is disposed of then.
Disposed of?
Yes.
Yes.
Grateful, my lord.
No need to keep it pending.
No, yes.
In item number 7, I am on behalf of the petitioner.
This is also interest from that.
Similar matter, Lordship. Revised PPO,
Revised PPO,
revised PPO.
Shojbo, revised PPO. Disposed of.
Obliged,
State,
Lordship.
who is appearing in this matter? Who is appearing for the state in this matter? Okay.
হ্যাঁ, বলেছি তো, affidavit of service দিলাম।
Shall I record your name? Who is appearing?
I am not
Shantanu.
appearing, my lord. If my lord directs, you can record my name and I'll appear then.
Shantanu. ঠান্ডাটা কমিয়ে দিন। বেশি করে।
It must be the duty. Can I record?
Disposed of.
হ্যাঁ, affidavit of service।
Yes, my lord.
You want me to regularize your appointment in this matter, or you'll be appointed directly?
Well, regularize my appointment then.
To show the affidavit of service. Paragraph, none appears for the state respondents despite service. Paragraph, Mr. So-and-so নামটা দিয়ে দেবেন, who is present in court and usually represents the state, is requested to appear for the state in this matter. Stop, his appointment be regularized by the office of the learned legal remembrancer Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon Mr. So-and-so in course of this day. Please serve a copy of the writ petition. to me.
Yes, my lord, yes.
তারপরে order. In this matter, Mr. Shaha's name has been given.
My lord, he is appearing unanswered.
You are appearing in the earlier matter.
No, no, my lord,
Second, you are appearing.
yes, no, since we have to,
So I cannot regularize the others. When there is no representation, I can regularize it. Okay, take it.
no, my lord, we are not, when we are appearing together, my lord, since,
So then give your name.
yes, my lord, sir.
Regularization is not required.
Yes, my lord, it is required then.
Regularization is required only when there is no representation of the state. Since Mr. Shah is representing, I cannot regularize another
Oh,
appointment.
yes, 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 my lord.
If you are appearing with him, you can give your name. Shajo, what take it?
My lord, I am for the petition, my lord. My lord,
Yes,
this petition, my lord, came up for hearing, my lord, came up as motion yesterday, my lord.
yes.
Now, today I want to add something more.
Have you served?
Not sir, my lord, it was heard yesterday, my lord. They were supposed to bring instruction, my lord, as regards to whether the opportunity of being heard was given or not. Personal hearing, my lord, if your lordship remember. My lord, the gist of the case was that under section 67 of the West Bengal value added tax, my lord, they have a power to search, inspect and seize, my lord. My lord, they went for a search. My lord, I am a reseller of cooked food, my lord. If your lordship very well knows, my lord, the Haldiram concept, my lord, whereof the sweetmeats are sold, my lord. Along with that, my lord, certain snacks or cooked food is also sold. Now, my lord, after going over there, my lord, I manufacture my sweetmeat at a particular place, my lord. After it is manufactured, my lord, at the 4 outlets, my lord, I divide it. And the cooked food, my lord, as per the order of the person who comes in, my lord, the order is placed. I cook it, the idlis, dosas, my lord, everything, my lord. I cook it and I serve it. Or by way of my lord, Swiggy or Zomato, my lord, it is taken away. It is taken. Now, my lord, as per the GST law, my lord, this sweet meat, when it is sold, my lord, it is taxed at the rate of 5% with the input tax on the inputs which is used in manufacture of this, it is allowed. In case of my lord, cooked food, the tax rate is also 5%, but no input tax is allowed. My lord, this is a basic difference. Now, my lord, in my shop, my lord, if it is a concept of Haldiram, my lord, there are certain, my lord, sweets, but there are certain biscuits, chocolates, cold drinks, etc. sold. So, my lord, I accordingly, my lord, charge my rate of taxes, my lord, at the rate of 5%, and the biscuits and everything, my lord, the cold drinks are at the rate of 28%. The other certain goods are at the rate of 8% and 12%, my lord. Accordingly, my lord, I make my accounts and I pay the tax. Only the problem was that, according to me, the cooked food which was sold, my lord, the input tax ought not to have been availed, but I had availed it. Now, my lord, they came. Now they are making out a case. They gave me an order, my lord. This is a pre-so-cause notice, my lord. I'll just hand over the book, my lord. Rule number 142, my lord. I'll just help, my lord, for the.
Is Mr. Ghosh ready with the documents today?
Yes, yes. Let I have called for the entire record.
You have to file them. They should be on record
If Miller desires.
because that is the basis of
Yes.
the matter. The
Madam.
documents should come on record by way of an
Madam.
affidavit
Madam,
after
madam.
service of copy
But
upon you.
if I complete, my lord, let them produce it, my lord. That can be taken on.
No, it cannot be heard like this. I mean, the documents should come before. That's relevant, isn't it? If you have not been given an opportunity, the entire matter goes in your favor
My lord.
without even going into the merits.
My lord, section 75(4), it very categorically says that if, first of all,
Yes.
and if I ask for a personal hearing, it has to be given.
You have shown that.
Or
yesterday.
there's an or. In case where an adverse order is contemplated against the petitioner, in that case, without any seeking of an personal hearing, and personal hearing is
The
taken.
authority says.
Yes.
Supreme Court says, yes.
Now, my lord, if they have given the personal hearing in between the reply to the so-called notice, whereof I have sought the personal hearing, my lord, and in between the passing of the final order, my lord. In between, if the personal hearing is given, my lord, I go. This is my case. But my lord, before that, my lord, they gave.
Before going into the merits, I feel Mr. Ghosh has to come with the documents showing that personal hearing was given to you.
Yes, my lord, we can come back. My lord, I have the documents ready with me, the original and the photocopies
Come on
also.
an affidavit, because
As
that's
my lord
the-
desires.
Lordship,
that's
We
where
have
the
no
case is
difficulty.
standing.
My lord,
basically.
lordship satisfy your lordship, my lord,
Yes.
whether it is a case there where otherwise it can be disposed of, my lord.
Because Mr. Ghosh says that you were given an
Yes,
opportunity.
my lord,
Well,
my case
lord,
is,
let
my lord,
the-
my case is that this was a proceeding under section 74. Now 74 is, my lord, a self-contained code which lays down a particular procedure. The scope of personal hearing or, my lord, a right of hearing has been inbuilt in 74 itself, that has been squarely complied with. Therefore, 75, in addition to that, 75 may not have any application to this. And wherever, my lord, this opportunity was required to be given in terms of 74, read with Rule 142, he has been granted ample opportunity in accordance with law. And that is, my lord, reflected from the order sheets also. Whenever he has been heard, his endorsement and his representative's endorsement is also there in our hearing notes.
So
But
that is why
in between the reply and the order, there was no
Yes.
hearing.
it is not coming clear, my lord.
Milad, no, Milad, there are three stages: pre-show cause, show cause, and Milad.
Reply.
No, pre-show cause, not show cause as such. Milad, an intimation of tax, then final order. In between intimation of tax and final order, there is no requirement of hearing. Requirement of hearing is the pre-show cause notice, the predetermination notice, that this is the tentative calculation of tax against you. In between that notice and the determination of tax notice, in between that, there is a requirement of personal hearing, because only then your audience is required.
What is the harm if a hearing is given to him and then an order is
Well,
passed?
this will be contrary to the statute. Contrary to the statute,
Where does the
absolutely contrary to the
statute,
statute. Yeah, the statute is very clear. Statute is
prohibit
very
this?
clear. If
My
you
lord, lordship once
Milad
visits, my
allows
lord,
me
the
to-
statute, my lord, lordship, one comes to the statute, my lord, 74 and thereafter 75. My lord, given the,
Oh, you did it.
Milad, if Milad desires us to bring these order sheets by way of a,
Because it is not a
report-
dispute that hearing was given prior to the reply of the petitioner.
yes.
That is not
yes,
disputed.
Yes, that is
And there
not
was no
disputed.
hearing after the reply was given.
Yes,
Right?
yes, yes.
So let us, on that basis, let us deal.
that
with
is
it.
why I said that this is to be verified, my lord, whether he's
Section 75.
74, my
isn't
lord,
it?
74, my lord, once. Would you come, my lord?
Yes,
My lord, the heading says determination of tax not paid, short paid, or erroneously refunded, or input tax rate
yes.
wrongly availed or utilized by reason of fraud or willful misstatement or suppression of fact. My lord, there is the determination of tax, my lord. My lord, now, my lord, section 75, my lord, the head note.
Give me a minute, please. This is issuance of notice and payment in 74.
My lord, 74 is determination, issuance of notice, and the quantification, my lord, not payment, my lord,
Quantification,
quantification.
yes.
And also
Payment is
the,
subsequent.
and also the procedure, how this has to be done.
My lord,
Milad, my submission
74,
is
9, my lord,
itself
lordship
is a
comes from-
self-contained code.
75, 74, 9, my lord. The proper official shall, after considering the representation, if any made by the person chargeable with tax, determine the amount of tax, interest, and penalty due from such person and issue an order. My lord, lordship come, my lord,
74?
9,
74/9, yes, I'm going
Yes.
to
Madam.
that, yes.
thereafter. But this is the
Milord,
only,
Milord,
Only-
what I would, Milord,
Milord,
Milord, I'm sorry for the interruption.
if I complete,
Milord,
my lord, if
no, no,
it's,
the accent. What I suggest, Milord, instead of picking up the provisions in a,
let us read down the provision.
Milord, kindly go through the provisions.
I have
Milord.
gone through.
My lord,
I
Yes,
have been going
yes.
through it, yes. These are the various steps.
Yes, correct, yes,
9 is there, yes.
yes.
And before that,
Yes, I've seen that, yes.
সেটাই তো বলছি।
74 is determination of tax, my lord, and the general provision is 75, my lord.
Yes, yes. I'm afraid, Mr. Ghosh, section 75,
Yes.
1, 2, 3, and 4 are all independent of each other.
No, my lord.
They are 4 separate occasions. The first one is when service of notice is stayed by a court or appellate tribunal.
My lord,
Second is
my
when,
lord, kindly starts from subclause 1.
yes, one
Subclause 1.
says,
My lord,
yes.
where the service of notice or issuance of order is stayed by an order of a court or appellate tribunal.
That is one situation. Please, that is one situation.
My lord, kindly, my lord, let us,
Yes.
my lord, go through the provision.
Yes, yes.
The period of such stay shall be excluded in computing the period specified in subsection 2 and 10 of section 73 or subsections 2 and 10 of section 74 as the case may be. Stop. Second occasion, where an appellate authority or appellate tribunal or court concludes. So, my lord, the second situation, therefore, is a continuation of the subclause 1.
No.
My lord, the first, my lord, the first, my lord, the
Please,
first
please.
provision, where the service of notice or issuance of order is stayed by an order of a court or appellate tribunal. When it is stayed,
The period is excluded. That is
excluded,
one situation.
one situation. The second
Another
is,
situation, and
where-
these
where-
are all independent situations.
yes, the appellate authority,
They are not
appellate
connected.
tribunal or court concludes that the notice issued under subsection
This
1
is
of
another
74,
situation.
it not, yes.
Yes.
And my lord, both the situations contemplates a scenario where appellate tribunal or a court has already interfered into the matter.
The first one is connected to 73.
Correct.
Second one is connected to
70
74 1.
74 and 73 also. Can
No.
we see the last expression? The
As
proper
in
officer
notice was
shall
issued under subsection 1. Yes, that is.
73 and 74. But my contention is, my lord, 75 deals with a situation, entire 75 deals with a scenario where a court or an appellate tribunal
No.
has already interfered.
No,
My lord, kindly see, my
I
lord,
don't
3.
agree.
My lord, subclause 3. My lord, I'll try to persuade. My lord, 3.
Yes.
Where any order is required to be issued in pursuance of the direction of the appellate authority or appellate tribunal or court, such order shall be issued within 2 years from the date of communication of the said.
Yes.
Dada, ekটু দাঁড়াও না, please. Of the said direction. So, my lord, 3 again is a situation where the order is required to be issued in pursuance of the direction of the
Yes.
appellate authority. In these 3 contexts, when an order passed under 73 and 74 after interference of the appellate tribunal or the tribunal is sought to be interfered with, 4 comes into play, that an opportunity of hearing shall be granted where a request is received. Because, my lord, kindly see, if this is not a possible interpretation, then 74 itself would not have made out a self-independent mechanism of ensuring personal hearing and natural
74
justice.
is prior to that. 74 is still assessment.
No, 74 is an assessment. Now read kindly, my lord, see section 74 along with rule 142. That will clarify the situation.
Rule 142.
142. 142 lays down the procedure as to how the substantive power under section 74 has to be exercised. Kindly take, my lord, rule 142.
Yes. Yes, 142.
Yes. Notice and order of demand. My lord, kindly mark the heading of the chapter, demands and recovery. Anything. Now, my lord, under the GST Act, demand and recovery can happen in many provisions. 73 and 74 are two of such provisions. We are saying that this is a case under section 74. Miller, can you see the marginal note of 73 and 74 once? 73 is determination of tax not paid or short paid or erroneously refunded or input tax
That
credit
is
wrongly
74.
availed. 73. For any reason other than fraud or any willful misstatement or suppression of facts.
And this is included in 74.
Yes, and other than false statement, misrepresentation, 74 is cases by reason of fraud or willful misstatement
Yes,
or suppression. So the power to determine can arise in both these occasions, 73 and 74. We are taking recourse to 74. Now, the substantive power contained under section 74 has to be exercised in accordance with rule 142, which deals with demands and recovery in general. Therefore, 142(1), the proper officer shall serve along with the notice issued under section 52 or section 73 or section 74 or section 76, 122, 123, 124, 125 or section 127, 29, 30, a summary thereof electronically in form GST DRC 1. Notice, statement under subsection 3 of 73 of 74, a summary thereof electronically in form GST DRC 2, specifying therein the details of the amount payable. 1A, very important, Millard. The proper officer may, before service of notice to the person chargeable with tax, interest and penalty under subsection 1 of section 73, 1 of 74, as the case may be, communicate the details of any tax, interest and penalty as ascertained by the said officer in part A of form GST DRC 01A. Millard has noticed that. Now, Millard, kindly the next provision, where before the service of notice or statement, the person chargeable with tax makes payment of tax and interest in accordance with the provisions of subsection 5 of section 73, or as the case may be, tax, interest and penalty in accordance with the provisions of subsection 5 of section 74, or where any person makes payment of tax, interest, penalty or any amount due, he shall inform the proper officer of such payment in DRC 3 and 4. That is, Millard, immediately upon receipt of the notice, that is, Millard, DRC 1A, if someone decides that it is correct, I should pay this, he can pay, and that should be paid in form GST
This
DRC
is
3.
prior to service of the notice or statement.
Yes, yes, immediately upon
If
receipt
he
of the notice.
spontaneously pays, no. Prior to, before service of notice.
Yes, before service of notice.
Not
Yes,
immediately
correct.
after.
Millard is right.
Yes.
Yes, before service of notice. Where the person, Millard 2A, this is again very important, where the person referred to in subrule 1 has made partial payment of the amount communicated to him, or desires to file any submissions against the proposed liability, he may make such submission in part B of form GST DRC 1A.
Yes.
He may make a submission. Where the person chargeable with tax makes payment of tax, interest under subsection 8 of 73, or as the case may be, tax, interest and penalty under subsection 8 of 74 within 30 days of the service of the notice under subrule 1, or where the person concerned makes payment of the amount referred to in subsection 1 of section 129 within 14 days of detention or seizure of the goods and conveyance, he shall intimate the proper officer of such payment in DRC 3, and the proper officer shall issue an order in form DRC 5 concluding the proceedings in respect of the said notice. Next, the representation referred to in subsection 9 of 73 or subsection 9 of 74, or the reply to any notice issued under any section whose summary has been uploaded electronically in form GST DRC 1, under 1 shall be furnished in form GST DRC 6. A summary of the order issued under 52, 62, 63, 64, 73, 74 till 120, 30 shall be uploaded electronically in form GST DRC 7. Therefore, Millard, DRC 1 is a step, DRC 01A is a step, DRC 07 is a step where no payment is made. A person is aggrieved. But my respectful submission is, so far as 74 is concerned, if it is a proceeding under section 74, in terms of rule 142, there is only one scope of personal hearing. That is immediately upon issuance of 01A. Once 01A has been issued, he has been communicated that this is what is proposed against you.
This entire provision rule is
Yes.
prior to assessment of tax.
But this is the procedure
The
of
rule
assessment.
is
No,
silent as to
Millard.
what happens after assessment.
Yes, DRC 7. That is Millard subrule 5. A summary of the order issued under 5274. This is the final order under 74. And the summary of the order is required to be uploaded, and the order is to be passed in DRC 7. So in subclause 5, the procedure ends. It starts with DRC 01A, DRC 01, and then DRC 7. Once DRC 7 is issued, the adjudication proceeding comes to an end.
Any provision prohibiting further application or representation?
Appeal, 107.
No, no.
Once an order is issued, Milord kindly sees. 6. The order referred to in sub-rule 5 shall be treated as the notice for recovery also. It is
Yes.
not only the final order, DRC 7, but also to be treated as a notice of recovery. Milord, the legislative intention is to cut short the process, since it is a matter of recovery of taxes. So, Milord, now, therefore, in between DRC 01 and DRC 1, that is proposed penalty, determination of penalty, and final order. Proposed penalty and penalty or tax, DRC 01A and 01, there is a provision inbuilt for personal hearing, representation, whatever you want to do. Once that stage is over, you cannot claim a further opportunity of hearing. Your next opportunity of hearing comes when DRC 7 is issued before the appellate authority. This is what, Milord, I am precisely meant to say. Now, Milord would see, Milord, here 74 is, Milord, being probably, Milord, wrongly subject to correction, is being intermixed with 75 to create a confusion, to canvass a case as if they have a right of opportunity of hearing as and when a representation is made. That is not correct.
Yes, that's all your submission.
Milord, 160, section 160.
Section 160.
160.
Yes.
Assessment proceedings, etc., not to be invalid on certain grounds. No assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or other proceedings done, accepted, made, issued, initiated, or purported to have been done so and so. Any of the provisions of this act shall be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission therein, if such assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or other proceedings are in substance and effect in conformity with or according to the intents, purposes, and requirements of this act or any existing law.
This is a different issue.
This is a different.
This doesn't-
Notwithstanding this, Milord always have the power of judicial review. Now, Milord, my only question is, violation of any natural justice has also to be seen from the point of view of prejudice, whether the petitioner has suffered any prejudice. Now, Milord, my order sheets reveal that not less than 3-4 occasions they were heard, their representations were considered, replies were exchanged, while the grounds you are invoking is not applicable in the case, personal hearing, exchange of representations, communications, no prejudice at all. No prejudice at all. At this stage, merely because of the fact that even after issuance of DRC 1, in between 1 and 7, you have popped up a representation in my email. Does that, Milord, give a right of personal hearing again? That is, Milord, a question to be addressed. In my respectful submission, it does not arise because you have already been granted, Milord, sufficient and adequate opportunities. You have a remedy, you are not remediless. You have an appellate forum. Subsequent to the appellate authority, you again can come back to this court, agitating or challenging the order of the appellate authority if you want. Where is the question of prejudice? And Milord, the
Where is
proceedings.
your 01 order?
Yes.
My lord, 83, my lord, starts.
83?
Man.
So that is 17th of March 2023.
Yes.
And intimation of the DRC 01A, which precedes 01, that is 1st of February 2023. We are going to kindly note this today. The 17th of March is DRC 1. DRC 1A is 1st of February. So there is a gap of about 1 month and 16 days. In between.
Where does the order say that the first line says that has replied in part B. So where
Yes.
is the endorsement that they were heard
Below the order.
in the order itself, in the impugned order?
Below the order itself, cannot be there, but not order state. We will record the proceedings, it is there.
The submission has to be recorded in the final order
Yes, it is
and dealt
recorded.
with and
Yes,
dealt
kindly,
with.
Milord,
Where
kindly
is it?
take the final order.
Yes,
The final order, Milord, to find 106.
83 is the final order.
No, the TRC 7 is the final order, that is 106. The time is Mr. Pawan Agarwal, Director of so and so, has replied to TRC 1 dated 2016 on 2026. The undersigned has gone through the submission summary on the following points are noted, following at the excerpt.
Well, I'll request, my lord, that the piecemeal picking up a certain portion should not be done by the.
No, I would
Counsel,
like to see that the submission of the petitioner was heard, taken into consideration, discussed in the.
My lord,
order.
lordship comes to 106. But he skipped, my lord. My lord, 3 lines he had read and thereafter he skipped, my lord. And
Yes,
that was
please,
intentional, my lord.
Please. I'm trying to find out, so let me give me some time. These are all the observations of the authority.
Yes.
Where is the recording that the petitioner was heard and these are the submissions of the petitioner which has been dealt with?
Well, 106 it has been recorded, my lord. 106 itself it has been recorded.
Your submission has been recorded?
My lord, lordship comes down to 106, my lord.
Yes.
That is why I said not to skip, my lord. My lord, Mr. Pawan Agarwal, my lord, he has read this. Of Makhanbo Private Limited, my lord, has
Has
replied to
replied in part B.
part
that
B
is a
TSC 01.
reply.
This issued on him on this. The undersigned has gone through the submission thoroughly. The following points are noted. No new objection has been raised by him. And my lord, it is a cut paste, my lord. Subsequently, the bottom line, my lord, I have, my lord, lordship comes down to page number of the DRC 01, my lord, A, which was the first notice issued upon me, my lord.
My point is different.
My lord.
When a hearing when a hearing takes place and a final order is passed, the petitioner ought to be heard. His submissions either accepted,
Recorded,
accepted or rejected.
the reason
Please
to be,
show me where it is.
the reason to be recorded.
Where is it?
Non-acceptance or
Yes,
acceptance.
where it is there.
Yeah,
I want to see that in the final order.
my lord.
The kindly comes at 140. You can see the chart, you can see the calculation.
114,
1 month.
yes.
A preliminary order has been sent to the RT. File memo number RT is not a registered taxpayer on 18/11/2020. A submission signed by Sri K. Sharma, advocate and heir of RT has been drawn.
My lord, 20, 25, 11, 22.
Reply that submission made against the preliminary order, I would like to state the point-wise reply as well. Each and every submission which was made has been dealt point-wise. With reference to submissions made in para A, it is related to matter of case. With reference to submissions made in so and so, I would like to say so and so. With reference to submissions made under the head submission of law, I would like to say that we are-
Mr. Ghosh, these are written submissions.
yes,
Where was he called and heard?
yes, that is prior to issuance of 01.
So when you file a written statement in the suit,
Yes.
you,
No, we are kindly, I respectfully suffering not to draw an analogy because when the GST bank was rolled out, it brought in a new set of design, which was meant to be different from the earlier provision.
so the person need not be called to clarify his objections?
Yes, before prior to issuance of TRC 01, because once TRC 01 is issued.
So the order
tax
should,
authority determines.
the order should reflect that his submissions were, These are written submissions. The person was not present at all when it was determined.
This personal hearing at this stage was not required under the act. You are kindly see, the DRC kindly note the date.
An objection was required.
Yes.
So when an objection is filed,
Yes,
it entails personal hearing.
yes, it was done. It
Where
was
is the
done.
personal hearing?
It was done prior to issuance of the DRC 201.
Where is, please show me one line that the personal hearing was done. The person or his representative was present before the authority. And was heard. Let the matter be decided on affidavits. There are several factual issues.
State Malad demand.
Now, Tamila,
Has to be stated.
what I apprehend, if Millard today records, returns a finding that even after issuance of DRC 01, a opportunity of personal hearing has to be given. That would be Millard probably Millard putting in an inbuilt condition over and above what is there in the statute. But I apprehend. Therefore, Millard, it must be on affidavit. Before Millard,
It is only explanation of, interpretation of the statute, nothing
yes.
else.
whatever it is,
It may be different.
that
but,
will open a new door of Millard hearing, which was till that Millard, which is not being afforded to registered taxpayer. Hearings are only afforded till the issuance. of
Prior
zero.
to, yes.
Zero. Prior to determination. Once the determination is done, before issuance of final order, only written submissions, no personal hearing. Now, Millard, that is what the act is. Now, if Millard takes a view which is not slightly different from that, Millard, it has to be on affidavit.
That's why upon hearing your submission, I feel there should be
Malad,
affidavits.
may I submit one?
Yes.
Malad, yes, submitted at a length, Malad. Well, Lordship, Malad, I'll subsequently, Malad, I'll place, Lordship, yesterday has been placed, Malad.
Your
yeah.
business is going on.
Yes, Malad,
And since the matter is pending before this court, you are protected.
Malad,
The law says.
Malad, very,
Right.
very, Malad, I know that, Malad.
So
but I'll
please come back on
Take
affidavits.
2 minutes of yours, Malad. Malad, what has fallen from the division bench of the Allahabad High Court and the division bench of the
Is it
Gujarat?
necessary? Please come back on affidavits. I do not want to decide the matter like
Fine.
this. Since a different
Malad,
aspect of the matter is being dealt with.
Malad,
It's
this matter
not
is
the-
already settled. Malad, he's unearthing a new law. He's stating that the GST is a new law. So all the legal position, Malad, to be kept on the
No,
rack.
I feel it should be settled once and for all.
Malad, it has been settled, Malad.
Because this
Gujarat,
will have implications on several other cases.
Yes. Definitely.
Malad, already Gujarat, already Allahabad has settled, Malad, this. This is nothing new to come, Malad. It has already settled, Malad. And if your lordship says that
This
by
court
exchange of
may
affidavit,
find
Malad, I'm
something-
well.
This court may find something.
Malad,
new
Malad, Malad,
in
Malad,
addition
let
to what
the
has been
affidavit be
settled.
exchanged, Malad. So in that case.
But Millard, there should not be any interim protection. as-
My lord,
Not
my lord.
necessary. Interim protection is not necessary because you are protected by the fact that the petition is pending. The law says so. The period will automatically be extended.
Well, no recovery, my lord, in between. No course of action.
Cannot be.
My lord.
Because the period, if the period of
My lord, my
payment is automatically extended, there is no question of a
My lord, my
recovery.
lord, I am accepting.
The order of demand dated 18th May 2023 in DRCO 7 is assailed in the writ petition. Paragraph upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that the matter needs to be heard on affidavits. Paragraph affidavit in opposition be filed within 2 weeks, Mr. Ghosh? 2 weeks? You're ready with the documents? Within 2 weeks from date, stop affidavit and reply, comma, if any, comma. It will be a very interesting hearing, actually.
Yes.
Be filed within a week thereafter,
My lord.
within a week thereafter.
Millard, if I may propose, Millard, subject to Millard's consent, Millard, I submit my affidavit within 3 days. Millard, their reply with the desired it to be done in 1 or 2 days. Probably Millard will be up from next Thursday and
It will not be possible. In 1 day, it will not be
Millard,
possible.
something will happen.
You know, there are a lot of matters. You know what is happening, a lot of matters.
Our pleasure to do it before last, Millard has appreciated the issue. Millard,
I would have loved to do it, but I don't think it will be possible. Hearing matters cannot be taken up at all. And if I take up this matter, leaving all other matters,
Millard picks up Thursday, Millard, 3 p.m.
and
Millard,
I don't think,
we will
it will
take
not be, I have to pass an order. I do not want to carry it back to, I do not want to carry it back to Calcutta. Because I have a very busy schedule there. I cannot carry the matter back to Calcutta. I'm sorry. Everyone will give a patient hearing. It's a very
This is what
interesting
your
matter.
lordship does, my lord. Even I appeared before your lordship, my lord, in the matter of, my lord, e-Diksha, my lord. The registration one, my lord.
Yes,
My
yes.
lordship has, you know, given a patient hearing, my lord, to each and everybody.
Well, lordships cannot be impatient, isn't
Well-
it? We have to give a patient hearing to all the matters.
Grateful lordship.
Next, okay, let the matter appear under the heading hearing before the next available circuit bench. It's very difficult with the hearing matters, Mr. Ghosh. So many motions,
Right.
hearing matters are not being taken up. And this is the difficulty with all the circuit benches, I think. I mean, it will happen in every circuit bench. We have to fix a designated day or something for hearing. Let me think about it. Let me think. A week will not be possible. Motions will all be there.
In fact, my lord, the principal bench, my lord, this matter was placed before the principal bench also, my lord. There is a stay and the matter has not been decided, my lord. The
But
affidavit has not been. filed.
Now there will be no scope of placing the matters with the principal bench because it's a regular circuit
Yes.
now.
Yes. That is.
Earlier, the gap you could move before the principal bench, but now
Yes,
that will
yes.
not happen.
Yes.
And this is better, much better.
My lord, very true.
You don't have to travel to Calcutta.
Yes.
all the- Yes,
No, my lord, we
yes,
are coming from there.
the other way around.
Yes, other way around. Grateful lordship.
I am appealing for the petition.
Who is appearing for the respondents?
Lordship, the petitioner's land, there is a
Indian
petrol,
Oil Corporation, Mr. Ghosh.
Yes. Petrol pump, and that petrol pump was acquired by the respondent authority. And the rent from March 1993 till 31st July 2013.
They are the requiring body, isn't it? How can they acquire?
Lordship. So I am demanding this rent from March 1993 till 31st July 2013.
Oh,
The
they are
petitioner-
tenants under you or lessees. What are they under you?
Lordship,
Who are they? Who are the respondents? Lessees or tenants?
they are tenants.
They're tenants. So you are saying acquiring. That's why I was a little confused. They are tenants under you.
Yes.
And they have not paid rents.
I
From?
have made representative from March 1993 till 31st July 2013, Lordship. I have made representation, Lordship. Kindly see. Page 37 to 39. Lordship. Let them consider my representation. Give a result order within 1 month.
This is a demand notice. This is not a representation. This is a demand of justice. Where is your representation?
Before that, there is a representation, page 34,
Let that be considered.
Lordship.
Page 34. Yes, Mr. Ghosh, you are enjoying the property without paying rents. The representation, yes. Affidavit of service. The petitioner claims to be the owner of the plot in question. Which was leased out The plot in question originally belonged to one Babulal Singh, who leased out the same in favor of one Messrs M/S Caltex India Limited. by virtue of a registered deed of lease dated 9th January 1969 for a period of 20 years, commencing from 1st February 1969 with option for 2 successive renewals for 5 years each. Stop. The lease expired after expiry of the renewals on 31st January 1999. Stop. The erstwhile owner also expired and his legal heirs transferred the land in favor of the petitioner, vide 2 registered deeds dated 29th March 1993 and 2nd April 1993 respectively. The property was taken over by the Indian Oil Corporation Limited from the erstwhile lessee though no fresh deed of lease was executed by and between the parties. Stop. The petitioner is not the owner at all now.
He is the owner.
Petitioner subsequently sold out the land to one Dulal Chandra Das. Paragraph 10 of your writ petition.
Yes, sir. Now he is not the owner, but at the
So
time,
he's demanding area rents.
at the time, he was the owner.
The petitioner subsequently transferred the land in favor of one Dulal Chandra Das, vide deed dated 2nd August 2013. Stop. The petitioner submits that area rents for the period 1st April 1993 to 31st July 2013 have not been paid by the respondents. Stop. The petitioner submitted a representation before the respondents seeking demanding the area rents. Submitted representations on 7th May 2012 or 2013. What is the date?
2012.
On 7th May 2012. Demanding areas of rent, which is yet to be considered. Stop. The petitioner plays for a direction upon the respondents to consider the representation and clear all area rents at the earliest. Paragraph, it is submitted on behalf of the respondents that the, who should consider, Mr. Ghosh?
Respondent.
Two,
Yes, my lord. Two.
that the second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such. Within 2 weeks.
Yes.
Within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law.
Keep your.
Paragraph, necessary consequential steps be taken by the authority within a week thereafter.
Server copy, let them act upon the server.
That will be recorded. Kashu, chat to you. Disposed of?
My lord, appearing for the petitioners, my senior would be joining through video conference.
Where is he?
He's there, he's online.
Who is appearing for the respondents?
For the state respondents.
I am appearing for CGST.
I'm appearing for petitioner.
Yes. Yes.
Lord, this matter, Lordship, happens to be the adjudication order has been passed under the section 73 of the GST Act. Now, before Lordship gets into the brief, Lord, this adjudication order was passed under section 73 of the GST Act, and thereafter the order was passed of adjudication against which the appeal was tendered by us. Now, the appeal had been removed on the count of a delay of 36 days without even going into my condonation of delay application. But before impugning the appellate order, my lord, Lordship will kindly come to page number 21, which happens to be the show cause notice under section 73. Here, Lordship will see this is a cyclostyle
Page number 21.
form, my lord, 21. Annexure P1, Lordship.
Annexure P1 is 22, yes.
22.
Yes.
My lord is taking WPA number 1523 or 1520?
1520.
20. Very well, Lordship. I'll address from 1520. So here, page number 22, Lordship will see this annexure happens to be a cyclostyle order notice under section 73.
Yes.
It has come to my notice that tax due has not been paid or short paid or refund has been missed erroneously, or input tax credit has been wrongly availed or utilized by you, or the amount paid by you through the above referred application for intimation. But this is something which is it's a cyclostyle thing. What you kindly turns the page to the page 23. Here, there's a table. This table is of utmost importance because anything that is of any value is given in the table. Number one, the section under which the show cause notice or statement is issued is 73. Date by which the reply has to be submitted, that is 17/9/2022. Date of personal hearing not applicable. Time of personal hearing not applicable. Venue where personal hearing will be held not applicable. Now, Lord, since this was a show cause notice where I had to explain the authorities because the claims are pretty tall, whatever has been made against me. Now, they do not give me any opportunity of being heard without me having the date of hearing, time or venue of hearing. Lord, I cannot effectively controvert whatever they're seeking against me. And Lordship will see the demand details just thereafter, it is as it is narrated. They have simply given a tabular structure of tax, and thereafter on the next page, the next page, that is 25, Lordship kindly refers to. This is the list of the order that is they seek to pass. Upon examination of records, it is found that you have availed excess input tax credit through GSTR 3B than available in GSTR 2A or 2B. Now, Lord, if I need to put my books in front of them, then I need to be entering my appearance in front of them. Without putting my books in front of them, I can be never able to reconcile between 2A and 3B. Now, let us not jargonize what is 3B. 3B is the claim that I submit to the department. That is a form of return through which I claim my input tax credit. And 2A or 2B is an auto-populated return which gets generated by the which gets generated by the server itself. And this server it generates this return by way of taking data from different other people who have filed their returns already. Now, if somebody else makes a mistake, then my lord, I am also made to pay the brunt of it. Just because my 2A or 2B, I cannot have any control over my 2A or 2B. I have full control over my 3B. Now, once they auto-populate 2A and 2B, I have no other reason, no other way but to appear before the authorities and show them my books of accounts and enunciate that how my claim is of value, how my claim is not futile. But here, no such opportunity of being heard was ever given to me. Only reply cannot conciliate the differences in the accounts. There the documents have to be produced, the accounts have to be produced. None of that sort was given to me, no opportunity was given to me. Another aspect, my lord, will see, this petitioner, thereafter, my lord, summary of show cause notice was issued and finally demand was raised under section 73. And lordship will see this is a 73 proceeding. This is not a 74 proceeding.
Yes.
My lord, I only indicate this by way of saying 73 and 74 because 74 is where the intention is wrong, where there's a fraudulent element, where is an element of dishonesty, 74 is used, and when there is a mistake, 73 is used. So
Yes,
this is a, yes. So this is something under section 73. And now lordship will kindly see page 28, the order, the adjudication order. Again, it comes with a cyclostyle format. And thereafter, the actual order lordship will get at page 30. Page 28 is the formatted order under section 73 where the calculations are given. And then at page 30, my lord will see the order itself. Same thing. Upon examination of records, it was found that the instant registered taxpayer, hereinafter referred to as the instant RTP, had availed excess input tax credit through GSTR 3B than available in GSTR 2A2, details of which are as below. Now there are these tabular forms which has been given, and thereafter further examination also revealed that difference exists between total outward taxable supplies as declared by the instant RTP in GSTR 3B as disclosed by his tax deductor TDS in GSTR 7, details of which again given below. Therefore, the net liability stood out as this. The instant RTP was thereby advised to deposit or reverse the excess IT and the tax unpaid due to undisclosed turnover, as mentioned above, along with the applicable interest and penalty, and an intimation through GSTR 1A was issued to him. Upon non-compliance, GSTR 1A issued the next page, lordship. The instant RTP did not submit any reply till date. Also, no payment has been made till date against the outstanding liability. Neither the instant RTP nor his authorized representative has appeared till date before the undersigned for any hearing or providing any submission regarding the matter. Lord, I pause here for a moment. I asked this question to myself, was this opportunity ever extended to me? Unfortunately, there was no such opportunity extended to me. Here now he writes and records in his order that neither the instant RTP nor any of his authorized representative has appeared till date. My lord, I was never given an opportunity. I did not know even before whom to appear, because a person who is issuing me the show cause notice might not be the adjudicating authority. So I cannot just go to him, and no place, venue, nothing has been provided. Lordship, once again, I'll take you, lordship, to the show cause notice, which is at page 22. My lord will kindly come once again in the backdrop of this order.
Yes, yes.
Effective page will be page 23, my lord. Section under which show cause notice saying 73, date by which reply to be submitted 17(9), date of personal hearing not applicable, time of personal hearing not applicable.
When did you submit your reply?
My lord, I could not file my reply. That is because these allegations can never be replied by a letter. I cannot simply say that no, my 3B claim is fine and your 2A to be auto-populated 2A to be contains the mistakes. because whatever data they are showing me, I also have to go through their inputs, because where they say that this 2A is not applicable to you or this calculation is not applicable to you, I have to cross-check with my books of accounts that whether this is at all paid by me or has it been a yesteryear due. Is it carried forward or is it not carried forward? That has also to be seen. And thereafter, my lord, may I, my lord?
Yes, yes.
Yes. And thereafter, my lord, will see that this notice here, the signature is not there. Of course, it is uploaded in the portal, so there is no signature. But the name and designation of the authority concerned has been given. But I could not have been sure that this is the authority who will be my adjudicating authority. And thereafter, my lord, will see why I could not file the reply from 34 till 43 medical certificates have been annexed, which was also the reason which prompted the delay of 36 days in filing of the appeal. So that was the reason, my lord, the partner concerned, who were the person concerned who was looking after the matter, they were completely bedridden. And for that matter of fact, my lord, I have also given this tuft of medical certificates. And lordship will kindly now come to the appellate order, or rather my memorandum of appeal. My memorandum of appeal contains a very detailed condonation of delay, which can be found annexed at page 54, annexure P7. My lord has got it, lordship?
Yes, yes,
Page 54, lordship.
yes.
Here I have, my lord, here I have tried to explain the reasons for which this instant delay of 36 days occurred. Lordship will kindly take paragraph 3. कैसे निकाल दिया?
Yes.
From the laptop, my lord, I have been disconnected. Lordship, am I audible?
No, now you're visible and audible both. Yes.
My lord, probably
Please
that has
continue.
been disconnected. That yes, yes, I have been connected. Lordship,
You
I have
are
been
visible.
connected.
Yes, yes.
My lord, I'm placing page 55, my lord.
Yes.
Yes. Paragraph 3, that it is submitted that the delay intentional and bona fide in nature. It is further submitted that when the proceedings were initiated, 2 out of the 3 partners were severely ill during the period January 22 to till date. One partner, Sri Bikash Mojumdar, who was suffering from severe anxiety, tension, arrhythmia, and under constant supervision of Dr. Shantanu Shiliguri and Dr. Professor Soumitra Ghosh, both are psychiatrist specialists and are taking sedative and other medicines daily in high dose. Copies of the prescriptions are attached herewith and marked as an extra capital A. The second partner, Sri Dev Kumar Chaudhary, is undergoing treatment in Institution of Neurosciences, Kolkata, for his neurological functional disbalance as well as heart complications and taking medicines on daily dose. Prescriptions are attached herewith and are collectively marked as Annexure capital B. The third partner, Sri Jitendranath Rai, is looking after not only the different sites of the work, but also partners who are suffering from such illnesses. And therefore, he was unable to see the daily requirements of the accounts as well as the authorized representative, so as to say the proceedings initiated by the department. Reeling with such situations, the third partner has informed that the recovery proceedings have been initiated by the department and notices in DRC 9 have been served upon different executive engineers. Finding no alternative, the partner had approached and engaged a new advocate. The said advocate, after going through papers, orders, has hurriedly prepared the memo of appeal, which has been ultimately submitted before this forum on 27th day of March 2023. That, as stated earlier, the petitioner was supposed to prefer an appeal on such and such day. The petitioner also gets 1 month grace period if cause is shown. However, since dealing with such situations of the illness of the two partners, there has been a delay of 36 days. That it is the contention of the petitioner that the right to appeal is a constitutional, no, my lord, constitutional right. No, it's not a constitutional right, it's a statutory right. Right to appeal can never be a constitutional right. So anyway, my lord, my humble submission is this, that the petitioner had tried his level best to cope with the situation, and he has also filed a detailed condonation of delay petition. Now, my lord will kindly see the impugned order of appeal at page 57.
It has been dismissed on the ground of limitation only.
Limitation only, my lord. It has been dismissed on the ground of limitation only. And lordship, if your lordship so requires me, I can share a judgment on the screen, because one point is perhaps taken by the revenue many a times, that under the GST laws 107, it does not permit them to condone the delay. They, being the creature of statute, they cannot condone a delay since it is not there in the statute. But that is a misnomer, my lord. The Honorable Division Bench of the Calcutta High Court, as my lord Chief Justice has already propounded on this issue, and the judgment has been promulgated by the Honorable Court, where it has been stated categorically that since 107 does not say that the authorities concerned cannot condone delay after 1 month, they have the power to condone delay even after 1 month. But I'm sharing my lordship's leave, my lord. I'm sharing my screen to my lord will
extend the period so that.
my lord, let me share my screen, lordship. If
It is not required because the authority says that they are ready to hear it out on merits. They concede to your submission.
my lord,
So
let
let
the
there be
matter
an
go
order
back
of
to
the
the
court.
adjudicating authority.
Let it be remanded back. Let there be an order of the court that they'll consider it on merits.
Yes,
My lord, let it be remanded back to the adjudicating authority himself, because I did not get an opportunity of being heard at the adjudication
The
stage
appellate
itself,
authority.
lordship.
It cannot
My
go
lord,
back to the
adjudication
adjudicating
my lord,
authority at the
they
moment.
did not give me an opportunity of being heard. I will
They
be
will
losing
give
out
you.
on a forum, my lord.
They will give you an opportunity. You have
I will
already
lose out a
preferred an
forum,
appeal.
lordship.
You have
My
lost
lord,
that
it is a
chance.
73 proceeding. My lord,
You
my
have-
learned friend will be
You
considerate
have
enough because
chosen to lose that forum, sir, on your own.
my lord, I was not
You should
given
have
the
come up
opportunity
before
of
this
being
court earlier, not after
Lordship,
the appeal.
True. But my lord, I cannot
So
improve
we
upon my
cannot
facts.
go back on it now.
My lord,
We
I
cannot
cannot
go back
improve
on
upon
it.
my facts, lordship.
I'll direct the appellate authority to consider your the appeal on merits upon
Lordship.
condoning the delay, right?
Within a finite time, my lord.
Absolutely.
I'm grateful
Yes,
to
let
my
that order be passed.
Obliged.
Third learned counsels for the parties. The petitioner carries on partnership business in the name and style of Messrs. Geeta Construction. And the business is duly registered under the West Bengal Goods and Services Tax Act 2017 and the Central Goods and Services Tax Act 2017. A show cause notice under section 73 of the Act was slapped upon the petitioner on 17th August 2022 demanding tax to the tune of rupees 12,11,148. And reply to the said show cause notice was invited from the petitioner within 17th September 2022. Stop. The petitioner did not submit any reply since no opportunity of hearing was granted to him by the authority. Stop. Intimation of liability was served upon the petitioner on
My lord, this was served upon me on September, 19/10/2022. October 19, 2022, Lordship.
on October 19, 2022. And the final order. This is DRC 7 order, isn't it?
My lord,
Under
DRC 07.
DRC 07, DRC-07 was issued on 19th October 2022. The
my lord,
petition-
referred to the show cause first. Did Lordship ask me the show cause notice date?
No. I asked you the, I'll give you, just a minute.
Because my connection faltered, Lordship.
The intimation of liability date.
Intimation of liability is the is contained in the show cause notice itself. It's a part of show cause notice. It's an
Very good.
annexure to the show cause notice,
Okay,
and that is, my lord, dated 17th August 2022.
yeah. কি বললো final order আছে না? তারপরে ওই হ্যাঁ তারপর the final order বলেছিল দেখুন। And now with the দেশে ওটা কেটে দিন and কেটে দিন the final order.
The
Final
intimation
order
of
was on
liability is
19th
dated,
October 2022.
my lord,
And you
my lord,
carried
my
this order in appeal.
in appeal on 9th. This appeal was filed on
The said order was carried in appeal by
My
the
lord.
petitioner
on March 27, 2023.
on
Page 55, Lodge. First line.
March 27, 2023, accompanied by an application for condonation of delay in preferring the appeal. Stop. The appellate authority, comma, by an order passed on 27th June 2023, comma, dismissed the appeal on the ground of limitation without going into the merits of the case. Stop. The petitioner prays for setting aside the said order and an opportunity of placing his grievance against the order impugned before the appellate authority. Paragraph, upon consideration of the submission on behalf of the parties and material on record, comma, this court is inclined to hold that since the petitioner intends to ventilate his grievance against the order dated 19th October 2022 before the appellate authority, comma, the appellate authority be directed to deal with the appeal on merits in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the respondent
Only
number.
one line, my lord. My
Yes,
lord, only one line that the delay stands condoned.
yes,
Only one line, my lord, that the delay stands condoned.
yes.
Right.
I'll record that.
Right.
In view of the above, the order passed by the appellate authority on
June 27, 2023, page 57.
June 27,
June 20.
2023
June
is
20.
set aside. Paragraph, the appellate authority, comma, being the respondent number,
My lord, he is the respondent number 2.
being the second respondent here in comma, is directed to deal with the appeal on merits without dismissing the same on the ground of limitation. Stop. It is expected, it is expected that the appeal shall be disposed of within 1 month, within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, comma, including the petitioner, comma, in accordance with law.
My lord, one
Grateful
line
to
may
the
kindly be added. The respondent number 4 and 6 also represented.
Also,
4 and 6.
4 and 6.
yes, I have not stated that they are not represented. You are appealing for all the all the.
No, for 4 and 6. And the state is for other,
Yes,
for other.
yes, so I, yes, give
4
your
and
names, give your names, yes. Represented, how you holding it? Disposed of or check?
My lord, same order may be passed in the next matter as well. Even the dates
are
are
also-
same.
Dates are the same?
The dates are also same, yes. Only the period is different.
Grateful.
Only?
Only the
Yes.
period is different. Your lordship
I have
has not referred to the
I
period
have
in
not
your
referred
lordship's
to the
order.
period. No, I
So-
have not.
Yes, yes. So that is, yes. The same order may be passed in
Same
the
order,
next
same
matter.
order.
The appellate order is also the same date?
The same date, my lord. The same date.
Same order. Why
10
should
and
same
11
order?
disposed.
10 and 11.
Both are disposed.
Same order.
Lordship, am I audible?
Yes, yes, yes.
My lord, I stand corrected. The impugned order of the second, the next matter is
Yes.
3/7/2023, 3rd
Yes.
July 2023.
Bashu. And the show cause notice is on the same date?
Focus notice is on the same date, 17th August, and the
Appellate-
and my lord, the
appellate-
order is also October 19.
The
Yes,
appellate order is on
July 3rd, 2023.
3rd July 2023. Appellate order. Appellate authority. Thank you. Yes.
Man,
Next.
man. I'm grateful to my lord.
13, my lord, I appear for the petitioner.
Respondents?
My lord, may I file the affidavit of service? Huh? Oh, yeah. My lord, I am against the
Mr.
confiscation.
Ghosh for all the respondents.
Yes, my lord.
Yes.
I am against the confiscation of my truck.
You are against?
The confiscation of my truck by the respondent, the state GST authorities, my lord. What has happened, my lord, my truck was carrying some consignment from Arunachal Pradesh to Jammu and Kashmir. Now, when my truck entered the state of West Bengal, near Siliguri, my lord, it was intercepted. And subsequently, my lord, it was confiscated. Now, admittedly, two documents, my lord, MOV1 and MOV2 were given to the driver. Now, unfortunately, my lord, I don't have a copy of that. I had a soft copy, my lord. It was, the printout was so illegible, my lord, I could not produce, but it will be there with the record, my lord. Now, my truck was, lordship, impounded, confiscated on 26th of December 2022. Since then, my truck is in the custody of the respondent authorities. I have made a representation, my lord, which is at page 18, praying for release of my truck. That has not been considered.
The ground is non-payment.
Allegedly, my lord, non-payment of taxes, my lord.
Your representation is at page?
Page 18, annexure P4.
This is also not very legible,
Which one, my lord?
the representation.
I'm sorry, my lord, first page. Second page, my lord, page 19 is where, my lord, I've made my prayer.
Non-production of tax invoice and delivery challan.
Yes, that has been alleged. Madam. But my humble submission is that since then, other than these two documents which was handed over to my driver, I have not received any further documents, any further demand of the tax, my lord.
So let this be considered, place your documents before the authority. Mr. Ghosh,
Because my lord.
I am not going to merits, let the authority consider,
let
let
the
him place all the
authority
relevant
will
documents.
Respond to it,
Yes,
whatever.
and let him place all the
But
relevant
I-
documents.
But I assume that proceeding must have been drawn, because there is a allegation, proceeding must have been taken carried forward, but we have not received anything, my lord, and as per one.
Since they have not received notice as yet,
Let them communicate.
let this be, yes,
Whatever is the
yes,
ground for-
absolutely, yes. Affidavit of service. Okay. We put a line to it. The petitioner contends that his truck carrying consignment from Punjab to
From Arunachal Pradesh to Jammu and Kashmir. My lord, the
from
consign,
Arunachal Pradesh to Jammu and Kashmir was intercepted at Panikauri,
Panikauri, my lord.
at Panikauri, no? Panikauri, comma West Bengal, on 26th December 2022. On the ground of alleged non-production of tax invoice and delivery challan. Stop. The truck is in custody of the respondent authorities till date. Stop. The petitioner submitted a representation before the concerned authority
Respondent number 5, my lord.
on 6th June 2023 and 23, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits. Respondent number 5,
5, my lord.
that the 5th respondent be directed to. Learned counsel for the respondents submits that the 5th respondent be directed to consider the representation in accordance with law.
That's 4. I am assistant commissioner of.
4th respondent, 5th, no, 4th respondent.
5th would be the affiliate authority.
Paragraph, in view of the above, comma, the writ petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated 6 June 2023 within 2 weeks or little more
It's a
time.
Confiscation matter.
1
sir,
month.
Let it be 7 days, not it's 7 days. Vehicle is under
Very
seizure, let them respond.
Within 1 week from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Stop. The petitioner shall be at liberty to place all relevant documents before the authority at the time of hearing.
Let it be 10 days. 10 days.
1 week na holo, 10 days. Within 10 days from the date of communication of this order. তারপর disposed of হয়েছে একটা line. Oh, একটা line করো উপরে. The decision taken by the authority, paragraph করে. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful, madam.
তারপরে petitioner যে চারটি line গুলো disposed of.
The next matter is similar, my lord. Similar, my lord. May I find the affidavit of service? Different track, but my lord, same dates.
And the allegation is also the same.
Yes, my lord.
Mr. Ghosh, you are appearing?
Yes.
So the same order can be passed?
Yes, my lord. The representation is at page 17.
Representation was 6 June 2023. আগেরটা তাই আছে আপনাদের? Representation 6 June. Same. And the truck was going from
From same Arunachal Pradesh
Same.
to
same order.
Jammu and Kashmir. Grateful.
Respondent number 4 here also?
Yes, my lord. Respondent number 4.
Yes.
My lord, difficult to get the state GST Act, where act, my lord. I've been told that Mr. Ghosh has purchased all the available books. Well, I have the petitioner, Sushant Millar,
Item-
from HON'BLE.
Item number 15, Your Lordship, I am appearing for the petitioner. Am I audible to my lord?
Yes.
Am I audible, my lord?
Yes, you are.
Lordship, before I take,
Respondents? Who is
Lordship,
appearing for the respondents?
the service is completed, my lord. The affidavit of service has
Yes,
been.
I'll just find her. Give me a minute, please. Oh, it's only the SMC.
Yes, my lord.
Yes.
Lordship, before I trouble you, my lord, with the papers, I'll just quickly indicate the premise of my case. Lordship, under Article 285 of the Constitution, properties that belong to the Union government are exempted from all kinds of taxes, including the taxes which are payable to the state government. The Shiliguri municipality, my lord, would come within the state of West Bengal. The property that I hold and occupy today, my lord, was transferred to me by way of a lease agreement wherein I was the lessee. The lessor of the property, who was the owner, was the Northeastern Frontier Railways, which is a state instrumentality, it's a central government instrumentality, and therefore the property which I hold, my lord, is not taxable, or the municipal tax, my lord, is not payable on that particular property. As a result, my lord, what has happened was that due to a flux of time, that lease agreement, despite being extended from time to time, has as on date, due to a flux of time, my lord, has to terminated. I continue to hold the property after the termination as a month-to-month tenant. I continue to pay the rent to the central government through the AGs of the central government, that is the Northwestern Frontier Railways. The specific cause of action for which we've approached my lord today, my lord, is that there were municipal taxes that were levied to me specifically, that is the month-to-month tenant. These were being levied prior to 2017. I make a representation to redress the same on the ground that under Article 285 of the Constitution, I am not liable to pay it, nor is the Northwestern Frontier Railways liable to pay it, my lord. I make representations. I move a writ petition before the Honorable High Court at Calcutta. Back then, my lord, this circuit bench did not exist. There was an order passed, my lord, 6th of December 2017, by which my representation was directed to be disposed of within a period of 8 weeks. The Shiliguri municipality has failed to do so. 8 weeks have surpassed. Back in 2017, they do not dispose of my application. There is another very specific line, my lord. I'll indicate to your lordship why I'm saying it. In the order passed by the Honorable High Court, in which it's specified that the merits of the case have not been entered into. So your lordship already knows that if today merits have not been entered into, and the liabilities and rights have not been finally adjudicated, therefore this can't act as res judicata against me. This is a well-established proposition, my lord, which is why I want to get this out of the way, because this might come as one of the plausible objections. So today, my lord, I did not take any steps. Admittedly, I haven't filed a contempt application either, because your lordship's directions were specific and the directions were final. So apropos my rights, nothing has been decided. From 2021 onwards, my lord, or 2022, I believe, they start issuing municipal tax invoices all over again. May I just take your lordship through two papers, my lord? Lordship kindly takes up page 16 once.
Yes, this is the earlier order.
This is the earlier order, my lord. Lordship can directly come to the second paragraph of the order. The first portion, my
Yes.
lord, is with respect to the objections that I have raised. Accordingly, I direct the Board of Councillors of the respondent municipality to take a decision in respect of the above representation of the petitioners with regard to the claim made by the respondent municipal corporation for payment of arrear property tax under reference by passing a reasoned order in accordance with law within a period of 8 weeks from the date of communication of this order, after giving an opportunity of hearing to the authorized representatives of the petitioner, as also other persons concerned, if any. However, I make it clear that I have not expressed any opinion with regard to the merits of this case, and all points are kept open. So my allegations have also been deemed to be denied because the learned court, my lord, the honorable court has not entered into the merits. Lordship kindly takes up page 18, the following annexure, my lord. I make over a copy of this order to the Shiliguri Municipal Corporation, my lord, by a letter dated January 31, 2018, so that steps in accordance with the order dated 6th of December can be taken. Till date, my lord, Nothing has happened. They have not taken any steps. And admittedly, if your lordship looks at page number 20 and 21, my service is complete. So they had
Yes.
naturally received it. Till date, no steps have been taken. Lordship kindly turns to page 23 once, which is annexure P3.
Yes.
This is in Bengali, my lord. We've given a translated copy, which is appearing on page number 24. There is a property tax, my lord, municipal tax, which has been levied for the period, my lord, starting from 1st of July 2008, my lord, to 4th of December. I'm sorry, my lord. This is from 2007-8 financial year to 2012-13, and then 2013-14, my lord, to 2000. This will be
21,
2021.
22.
This will be 21-22. Your lordship is absolutely. This will be 21-22. So I am not liable to pay, my lord, a single penny by virtue of say, Article 285. May I just
Let
kindly
them decide within a very short time. Maybe within 7 days.
Lordship, may I just I follow, my lord. I bow down to that. May I just trouble your lordship with Article 285 once, my lord. I'll indicate why the actions which have been taken by the municipality, my lord, is apart from being illegal, is also malafide.
Since subject matter in the present writ petition is similar to that of the earlier writ petition,
My lord.
let them take a decision. Let us hear the municipality.
Then
Yes. Take the microphone, please. Otherwise, learned counsel will not be able
This
to hear you.
allegation that the order of the High Court has not been complied, with the
Yes.
opportunity of hearing has not been given to him.
Yes.
Lordship, since at that moment of time, it was the earlier board, so it's not.
So earlier
I-
court was not responsible for complying the order.
I don't know the instructions regarding that, but since he's a lessee, a specific holding number has been issued in his favor. So in he's enjoying the
Have
municipal
you
amenity.
complied with the
legal
order
issue.
of the court, sir? Nothing more, nothing less.
Lordship,
Comply
grant
within
us-
7 days.
no, since this order was passed upon the BOC to take a decision, the BOC for this month has already, it was already.
I
held
do
on
not
to
know your
the-
BOC and COC. When there is an order, you have to comply within 7 days. I don't know how you will comply.
No, Lordship, kindly.
The order
appreciate
has
my-
been waiting for you to be complied from 2017. At your mercy. 7 days, otherwise you face contempt.
Then in that case, let it be directed the commissioner to give them an opportunity of hearing. Kindly direct them to bring all the records with all the documents.
Why, where has the Board of Councillors gone?
Now the Board of Councillors meeting will not be, this meeting will not be held in the next 7 days. It will be held, it will be end of this.
You can convene a meeting in terms of the direction of this court. If the court says 7 days, it has to be 7 days and not the 8th day. You've been waiting since 2017. Your Board of Councillors have not felt it necessary to comply with the order. So they have to hold a special meeting if it is necessary to comply with this.
No.
Because learned counsel refers to Article 25, which is very clear.
I understand, Lordship, but
It is
Kindly-
not for you to
kindly-
understand, sir. It is for
No,
you
no,
to
just kindly-
explain to your authority.
Yes, but Lordship.
It is not
kindly-
sufficient if you understand.
But kindly gives you.
Your
gives
authority
me-
should understand.
Kindly gives the corporation one month period, their grievance will be addressed. 7 days, Lordship, the POC meeting is scheduled on the. Now the problem will.
2 weeks.
Lordship, I don't stand in the way of that. My only difficulty is if your lordship looks at page 24, which is the tax invoice they've raised, the last sentence becomes very relevant. And this
No
is the
coercive action will be taken till a decision is taken.
very well.
No,
Right?
I'm deeply obliged. I'm deeply obliged.
It
Lordship
will
only
not be
records that
taken
bit.
to take a
It is not
decision,
to
right?
take against them.
Lordship only records that. my lord.
I
Protects
will.
my rights that. I'm deeply obliged.
Affidavit of service. The paragraph, it is submitted on behalf of the petitioners, that the petitioners are lessees in respect of the property in question, by virtue of a deed of lease executed on 18th January 1952, 1952, and even after expiry of the period of lease, comma, the petitioners are continuing to occupy the said premises upon payment of monthly rents. Payment of monthly rents. Stop. The respondent authorities made demands for payment of property tax to the petitioner for which the petitioners approached this court in a writ petition being WP number 14175 within bracket W, bracket closed, of 2017. Stop. By an order passed on 6th December 2017, comma, a coordinate bench of this court directed the Board of Councillors of the municipality to take a decision in respect of the representation submitted by the petitioners with regard to the claim made by the municipality for payment of area property tax under reference in the writ petition within a period of 8 weeks from the date of communication of the order. Paragraph. Learned counsel for the petitioners submits that despite such order, comma, the representation submitted by the petitioners has not been dealt with as yet. Stop. Paragraph. This is an unfortunate and alarming state of affairs when the respondent authorities choose to ignore a direction passed by this court in the year 2017. Stop. Strangely, comma, the respondent authorities have issued further demands for payment of tax upon the petitioners without dealing with the representation pending before them. Paragraph. It is submitted on behalf of the respondents. Who should deal with the representation? The commissioner?
The commissioner.
That because the board has not been made a party. Let the commissioner deal with it.
Yes, my lord. Shouldn't be.
That the commissioner, comma, Siliguri Municipal Corporation, comma, being the second respondent herein, be directed to consider the representation submitted by the petitioners in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioners dated
My lord, that representation is not a part of
14th
the,
March 2011.
and that was the original representation, my lord.
This was directed to be disposed of. 14th March 2011.
Yes, my lord. 14th March 2011 was the original.
Dated 14th March
Lordship,
2011.
may I only say one more thing, because I do not know if they'll be able to trace that, because otherwise they'll come forward again and say that I understand how the department.
Give a copy to them.
I will serve another copy also apart from this, your lordship. Along with this, my lord, would it be your lordship's pleasure to allow the writ application itself be treated to be a representation, my lord?
You can file a further representation if you want to.
Very well, my lord. Then in that case, my lord, along with the copy of the order that your
Along
lordship
with
is
the
passing,
earlier representation, yes.
I will make over another copy. They'll give me a personal opportunity of hearing.
কি বললাম? এটা কি দাঁড়া, এটা কি দাঁড়া, এর আগের লাইনটা কি? হ্যাঁ, এর আগের লাইনটা কি বলুন? ও, তার আগে একটা লাইন, পিটিশনারের সাবমিশনের লাইন। তার আগে। ওখানে একটা লাইন, ওখানে অ্যাড করো, ওটার পরে অ্যাড করো। হ্যাঁ। Since the earlier representation was submitted on March 14, 2011, the petitioners seek liberty to submit a further representation ventilating their grievance before the concerned authority along with a copy of the earlier representation. তারপরে যা বলেছি যা আছে সেগুলো থাকবে, তারপরে ওই ইট ইজ অ্যালার্মিং যেগুলো থাকবে সব থাকবে। ফ্রেশ প্যারাগ্রাফ করো, ইন ভিউ অফ দ্য অ্যাবভ। বুঝতে পারলে? এটা করো, ওইগুলো দেবে। In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated 14th March 2011, along with the subsequent representation which the petitioners shall submit within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, pending disposal of the representations, no coercive step shall be taken against the petitioners by the respondent authorities in connection with the demand notices issued by them. Disposed of? That should suffice.
Yes. I'm deeply obliged, madam. Deeply obliged.
Next.
Petitioner matter 16 and 17 are election matters. My lord will kindly take it up
Tomorrow?
tomorrow. My lord.
Not tomorrow, my lord. The reason behind this is pertaining to the Alipurduar district, my lord. Yesterday it has been served upon us. My lord, I had
You
a
need
talk.
some more time.
Is, my lord, because that instruction will come on Monday. Kindly give it on Wednesday, my lord. Because tomorrow the others matter, my lord, I will cover also this, but ultimately, kindly fix it on Wednesday.
Very well, but this was served on 31st of July.
I have a small doubt. Election petitions
I
should
will,
be
I will,
dealt with upon taking evidence.
lordship, I will, that I will show you,
They
lordship.
are specially assigned by the Honorable Chief Justice to different courts. So how can an election petition
No,
be taken up? at
no,
different
lordship,
states?
I will satisfy your lordship tomorrow. That's why I said,
Because we have been taking up election petitions at the
Lordship.
principal seat,
yes,
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 my lord.
where evidence is being recorded.
yes.
So without evidence, how can it?
No,
be-
lordship,
how
this is not
possible?
that. The election petition to be filed before the concerned court having jurisdiction. That is the mandate of the under the manual and the panchayat laws, my lord. That I will demonstrate tomorrow, my
But
lord.
the Honorable Chief Justice, my lord, as it has fallen from your lordship, subject to correction by your lordship, has assigned a special bench. to
No,
hear
no,
these
no,
matters.
no, not, no
We have
special. bench.
assigned these matters to several benches.
Several benches. my
Not a
lord.
single bench.
I was under the impression.
No,
my
no
lord-
special bench.
I deal with some of them, some
My
other
lord.
bench deals with some of the, it's like this.
Yeah, my-
It's according to assignment by the Honorable Chief
Lordship.
Justice. So
But-
unless these.
But,
election
my lord, this is
matters-
the pertaining to the circuit bench of Jalpaiguri as per rule 4, my lord. So unless both the parties are giving a consent, making a representation of the London Register, then London Register shall forward to the Honorable Chief Justice, my lord, then the assignment will come.
I may sound very technical, but then this is happening with all the election petitions. On the other day, I had a doubt. So
Lordship.
I'm just
Yes, yes,
sharing.
lordship,
it
I
with
will
you.
clarify tomorrow.
I'm just sharing it with you.
Lordship, I will clarify,
Because,
tomorrow.
Can it be taken up like this?
But the writ jurisdiction lies with your lordship.
Writ jurisdiction is different from election petition.
Here, I understand, but here, my lord, there no separate bench has been assigned to take up those matters. Now, as per the our circuit bench rules, my lord, when the circuit bench is in session, my lord, the cases are to be filed
Because
here.
election petitions are like suits.
Yes, yes, my lord.
A written
Yes.
statement has to be filed.
Yes.
Evidence has to be, issues
Lordship.
have to be framed.
Framed.
Lordship.
It's just like suit.
Yes.
Yes,
yes.
my
It's just like a suit.
The Milord, it has
So-
been well governed since 1954. The moment the election is over, Milord, then only remedy lies upon the particular court to dealing with those matters, with regards to the veracity of the complaints after the completion of the election, Milord. That I will come up tomorrow, Milord.
But here, my lord, tomorrow, lordship will hear the learned additional
Other
advocate.
matters,
But
yes, other matters.
I was just, my lord, thinking aloud that whatever has been submitted is all right. But the Honorable the Chief Justice has assigned certain benches in the Honorable Principal Bench to hear up these matters. Now,
So what happens to the circuit
yes,
bench
my lord,
matters?
what happens? Because the matters are to be filed here. Earlier, my lord, my lord knows that when the bench was not in session, the matters could have been filed there with
But
the
now
legal.
that scope is
Now
gone.
scope is also not there. Now a peculiar situation might arise that here the matters will not get heard for whatever reasons, my lord. Maybe the Honorable Court takes up the submission of the state and says that it goes to the court under the Panchayat Act. But certain set of petitions, my lord, which are within the jurisdiction of the Honorable Principal Bench are getting heard by the High Court. There, my lord,
By separate individual benches.
Yes.
Not one single bench.
Yes, but not, my lord, before the jurisdictional court as per the act which has fallen, my lord.
No, no.
Then,
It
my
is
lord,
not the correct proposition.
then, my lord, a peculiar situation will arise, my lord. The High Court in one set within one jurisdiction is taking up the matters, maybe specially assigned, but is taking up. And with regard to the circuit bench matters, my lord, then if it goes there, then I don't know, my lord.
It cannot go there. Maybe we can deal as and when it like here the writ court, there's only one writ court here.
Yes,
I
ma'am.
deal with all the writ petitions. So
Yes,
maybe
ma'am.
I'll deal with the election petitions.
Yes.
But then it has to be like that, like a suit.
Like a suit,
Like
You have
Lordship,
to file
like a
statement,
suit.
You have to
yes.
file, issues have to be framed and.
Yes.
then
Lordship,
it's
it
a-
will not be even to the lies to the writ court, Lordship. That I will tell you tomorrow.
No, no,
Lordship.
this is not beyond the writ court jurisdiction. This is
Yes.
election petition is a separate issue altogether.
Yes, ma'am.
Separate determination altogether.
Exactly, Lordship, but it is, as Lordship has said rightly, it is a suit, Lordship.
Absolutely,
It's
absolutely.
to be decided after the examination and the issues are framed. That Lordship to be decided. I'll
Because
come up
at the
tomorrow. I'll,
principal bench, election petitions are filed before the Chief Justice who assigns.
You assigns, my lord.
So here can you file before this bench? That is my
My lord,
question.
here the problem
At
is.
the outset, I said I'm being very, I may sound very technical, but then
no,
this is the
Lordship,
basic.
no,
issue.
my lord,
Lordship,
This is the basic issue.
I am just clarifying, Lordship. Lordship, the moment the circuit bench rule has come into enforce, the senior judge presiding over the circuit bench, having vested the power in deciding the matter to be decided for a jurisdiction. Suppose now, my lord, Lordship, the circuit, pertaining to the circuit bench, the election petition has been filed, then the honorable, the senior judge,
So why don't you, in that case, that be so?
but it will
Why
not,
don't you file a formal application before the senior?
My lord, subject to correction, I think.
I don't mind taking up the
no,
matters, but
but-
there shouldn't be a technical flaw, isn't it?
But
but
since-
only your Lordship is only having the determination, taking up the writ matters.
Yes.
No other court. So Lordship, there will be no technical difficulties in arising because the
Very well.
But
So I'll deal with.
Lordship.
yes, but as it has fallen from your lordship that there it is filed before the honorable, the Chief Justice and the honorable the
And then
Chief
it is
Justice
assigned.
assigns.
Yes.
Here, my lord, no such notification. So I believe, my lord, subject to correction by your lordship definitely, that if your lordship takes up this and then makes an observation in keeping in view the practice which has been going on in the principal bench,
Practice
then
in the
maybe.
Principal bench cannot be so much applied in
No,
this bench.
But
That is
then
the
in
issue.
that event, my lord, maybe we can approach the honorable presiding judge here that
it has been decided that the only the my lord is having the jurisdiction with regards
Since
to
there is only one court,
one court.
yes,
so I
Had
don't
it been
mind
there is
dealing
other
with it.
other
I'll
two
be very
courts.
happy to deal with it, but then
yes.
it's a long drawn process. You have to come up with written statement and.
Yes,
all that. So
Lordship, that is
Very well, let the matters appear.
yes,
let
yes,
us see.
tomorrow. Yes.
Let us see.
But these two
Yes.
matters were served in on
Come back
31st of
next week.
July.
Come back
I'll
next
come back.
week.
I'll.
These
Yes,
two
because
matters.
the issues are more or less my lord,
More
similar, more or less,
similar
more or less.
matters, my lord.
If the one issue is decided by your
Yes.
lordship, the other will follow.
No, Evidence has to be recorded
No, no, no,
separately.
no, no, no.
because the
That, no, no, no. If
allegations
your
are
lordship
separate.
decides,
Yes.
then one read petition with the pertaining to the election, then the other read petition pertaining to the election to be followed by a same order,
Same order,
which
yes.
your lordship is going to decide. That I'm saying.
Because all the matters will be placed before your lordship.
That I'm saying tomorrow,
Let us see.
tomorrow, suppose the lordship is deciding that this is the outcome of that after taking evidence, after the framing of
Yes,
issues.
yes, that will apply.
That
for
I'm
all.
saying, so
That will apply to
even
all.
if it is matter is posted on the next week, my lord, that same, you know,
Same, that.
Very well. So will you come back on Thursday? Next Thursday?
this matter,
These
my lord,
Thursday?
no problem,
Ten.
Wednesday or Thursday.
On prayer of the
Ninth, my lord, another matter has been fixed.
election,
Yes, my another.
Wednesday,
Wednesday.
No problem.
on prayer of the
Oto-
respondents, the
Oto
matter is
Calcutta.
adjourned. Paragraph, let the matter appear under the same heading on Wednesdays,
9th is Wednesday, no problem.
9th August.
Great, lordship, lordship. 16 and 17, next,
16 and 17.
17 same order. 17 or same order.
lordship, great.
Yes, well, I'm
Yes. Respondents? Served?
Yes. That is relating to interest on area pension.
Respondents? Anyone appearing for the respondents?
My lord, state, I generally.
You are appearing?
Serious nature that may not I represent, otherwise my states are.
Single PPO?
Single PPO Milo. Yeah, Milo only.
Let the same order be passed?
Yes, lordship.
Single PPO लिखे रखो कल. हाँ. Disposal.
Obidullah is online.
Yes,
Lords, I appear for the petitioner, Lords.
yes. Our respondents?
Lord, I have already served Lordship, immediate service is there, Lords.
Who is appearing? Who is appearing for the respondents? You are appearing for all the respondents?
My lord.
Yes,
Lords, may I place, Lordship?
yes.
Lordship, Lord, this is a case, Lordship, for Anganwadi helper, Lordship. The selection process was initiated, Lordship, in the year of 2009, Lordship. Thereafter, Lordship, on 14th March 2022, Lordship, the provisional appointment letter was issued to the petitioner, Lordship. Now, Lordship, after that, Lordship, on 14th March 2023, just after 1 year, Lordship.
Give me a
That,
minute. Please.
child
Give me a minute. Give me a
Lords.
minute, please.
Lordship.
19, yes. Monday he can come or I'll give you some more time. The respondents are seeking accommodation.
Wednesday.
Learned Council is suffering from viral attack.
Lordship. Lordship, in on similar circumstances, the order was already passed, Lordship. Case
Yes, please
27,
come back.
Lordship.
Please come back.
On Lordship.
On prayer of,
When,
affidavit
Lordship?
of service, protocol. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9.
My lord.
9.
Lordship, 9 have difficulty, Lordship.
10,
Lordship, 9th and 10th I have also difficulty, Lordship.
10th,
Lordship,
you're not
kindly
there.
keep it on Monday. No, Lordship. Kindly keep it on Monday, Lordship.
He's
Monday.
not well. He's suffering from viral fever. So the last day then, 11th. Short
Lordship,
matter
11th.
will be taken
Kindly
up.
keep it, Lordship.
11th.
Lordship, 11th. I'm great, Lordship.
And
Get. Yes, Milo. Single PPO.
State. Necessary order? Single PPO, disposal.
Yes, Milo. Single PPO. Petition is the live here.
Single PPO disposal.
One 622, Milo.
22, Lordship, I appear for the petitioner, Lordship. This
Yes,
is same as identical matter, Lordship, as item number 19, Lordship.
as item number,
19, Lordship.
the one which is adjourned.
Yes.
Who is appearing for the state? You're appearing?
I'm appearing.
Lordship.
Yes,
May I place, Lordship? May I place, Lordship?
yes, yes.
Lordship, in this matter, Lordship, 2009, Lordship, selection process was initiated for the Anganwadi helper and worker, Lordship. And during the after completion of selection process, Lordship, on 14 March 2022, Lordship, the provisional appointment letter was issued in favor of the present petitioner, Lordship. Thereafter, Lordship, after expiring of 1 year, Lordship, on 14 March 2023, Lordship will find the impugned order as at page 18, 18, Lordship. Lordship, the respondent number 7, Lordship, cancelled my appointment letter on the ground that I have submitted my schedule caste certificate after the letter on, Lordship. And thereafter, Lordship, I made it the representation by way of demand of justice. That has not been considered. Lordship will kindly see page 22. Lordship, during this time, Lordship, on 7th June 2023, Lordship will find page 28, Lordship. Similar circumstances, Lordship, the division a single bench of Honorable Judge, Lordship, has been pleased to pass an order, Lordship, by quashing the same order, Lordship. Lordship will find page 18, page 28, Lordship. On similar circumstances, similar order, Lordship, same date, Lordship, same CDPO. That means Child Development Project Officer. And that order is squarely applicable in my instant case, Lordship. Date of rejection is same, Lordship. The authority is same, Lordship. The point is also same, Lordship. Kindly consider the judgment at page 28.
Difficulties, my lord, in my petition copy, the order is incomplete, my lord, what they have served to me. So I have,
Page 28.
lord, yes, my lord, page 28, but it is not complete in my petition. I have just.
So all these petitions are served, Lordship, duly. I don't know why my learned friend says it.
The department is also not served. That I served it on instruction. The department has not received the read copy also.
Unnecessarily, they are dragging the proceeding, Lordship. This order is binding upon me, Lordship, also. This I have annexing the certified copy of the order.
Yes,
Well, my copy order is incomplete.
you have not given a complete copy of the order.
Not my matter, only I did the application.
Can you give him a learned counsel a
Give me order
copy?
copy, my lord, so I
I'll
can
come
access.
back at 2 PM then. Will you give him a copy in the meantime? Yes? Come back at 2 PM, please. You have not
Lordship,
served a complete copy to the learned counsel.
So I have already served, Lordship, all this party, Lordship.
The
They are not
complete copy is
disputing.
not there, sir.
Now they are if they are disputing now, Lordship, then what can I do, Lordship?
Yes,
kindly
because
come back
you
to
are
Lordship.
referring to the order which, you are referring to an order
Lordship,
which you have not
Lordship.
served. So please,
Lordship, it is already-
make necessary arrangements for serving the same by 2 PM. I'll come back at 2 PM and deal with the matter.
Lordship,
Yes,
Lordship.
please
Okay.
try and serve within 2 PM.
Yes,
Please come back.
Yes, ma'am. the same view. I have no objection to that.
Without recording your consent.
Yeah, without objection.
Let the same order be passed. Yes,
Lordship.
Whether it is the same post or not, that I have to check, my lord.
similar issue.
Completely similar issue.
You've not
Lordship,
read?
kindly see page 18. Page
Yes,
18
yes.
impugned order. Same authority, same date, Lordship, same issue.
Yes,
Yes,
yes.
my lord.
Affidavit of service.
My lord, let the state submissions also remain the same as the order is.
Very good. The order passed by the cannot be read. Who is the authority?
My lord,
Respond number 7, Lordship.
You've annexed all illegible documents.
Respond number 7, Lordship. The Child Development Project Officer.
Passed by the Child Development Project Officer, comma, Kuch Bihar, 1, comma, ICDS project on 14th March 2023 is under challenge in the writ petition. Paragraph, it is contended on behalf of the petitioner that pursuant to a notification issued by the Child Development Project Officer, comma, Kuch Bihar -Roman 1 on 20th November 2009 for recruitment to the post of Anganwadi helper the petitioner applied for the said post and was appointed as an Anganwadi helper. Vide memo dated 14th March 2022. Stop. On 14th March 2023, comma, the petitioner was served the impugned order cancelling her provisional appointment on the ground that the caste certificate of the petitioner was obtained subsequent to issuance of the notification.
Lordship, issue of notification. Lordship, you find page
Subsequent-
19, paragraph
subsequent
7,
to
2.
Issuance of the notification.
Lordship.
Paragraph, learned counsel for the petitioner submits that the petitioner belongs to the Scheduled caste,
Lordship, scheduled caste.
the scheduled caste by dint of his birth, and it is immaterial as to when the certificate, when the certificate was obtained by him. Learned Counsel has placed reliance in the decision of the, in the authority in Ram Kumar Gijroya, Gijroya versus Delhi Subordinate Services Selection Board, reported in 2016, bracket 4, Supreme Court cases 754, and an unreported decision of this court passed in WP number 15032 within bracket W, bracket closed, of 2018 on 28 August 2018. Stop. Paragraph. Per contra comma, Learned Counsel for the respondents submits that there was a specific condition that caste certificate was to be submitted along with the application for the post. Stop. The petitioner was unable to submit the same along with the application and applied for the same after applied for the same subsequently. So therefore, the authority rightly cancelled the provisional appointment of the petitioner. Paragraph. It is a fact that the caste to which the petitioner belongs is attached to him by dint of his birth and cannot be altered by way of a caste certificate later on. Stop. Production of a caste certificate is part of the requirement entailed with the application and whether such certificate is obtained before or after the application does not have much relevance comma, provided genuineness or validity of the certificate is not in question. Stop. That is not the case of the respondents hearing. Paragraph in view of the observation. In view of the observation made herein above, as well as the observation made by the honorable courts in the authorities referred to above, comma, this court is inclined to hold that the appointment of the petitioner cannot be cancelled on the sole ground that on the sole ground of late submission of caste certificate by the petitioner. Paragraph. Accordingly, the order impugned dated 14th March 2023 is set aside. Slash quashed. No further order is required. Where is
Lordship.
disposal? Next,
Lordship, item number 24 is the same, Lordship.
item number?
24 is same, Lordship. Same as 22.
Well, for I don't know 24 and what similar matters, well, there are different councils. I am requesting Viola to take it up serially. madam.
Serially, very well. 23. I'll just take it up serially.
Lordship.
Yes, but I'm for that.
Overall. Join.
One thing, my lord, here the autonomous has been deducted after issuing PPO. That is the
Overall amount has been deducted after issuing the issue.
kindly see the PPO. Here, madam, only last line only correct.
This order was passed the day before yesterday. It has been deducted.
Yes, deducted from the
So-
PPO.
So you're praying for refund. Jayant? One 146,274 is the amount.
14627. Second and third respondents, second and third respondents. I have
You have
done-
stated that.
Yes, I have. Treasury officer and director of pension provision.
Second and third respondents have it. And এই অবস্থায় হবে ওই জায়গাগুলো চেঞ্জ করবে। হ্যাঁ, আমি চেঞ্জ করে দিয়েছি। Only have to add that line that it was deducted from the PPO.
First in last line. Yes, refund.
Was compelled to refund will not be there. এই লাইনটা হবে না,
PPO was issued after deducting the same amount.
the এই during her service এর পরে হবে না, during her service এর পরে এখানে হবে the overdrawn amount to the tune of rupees 146274 was deducted from the pension payment order of the petition. এই লাইনটা খালি ওটার জায়গায় আর এটা কেটে দিয়েছে। Disposed of. It should be through the pension payment order or from the pension payment order?
Through the pension payment order.
Through the pension payment order.
It was indicated in the pension payment order.
No, through the pension payment. Right? Yes, next, 24.
24 lordship appear for the petitioner lordship. This same lordship as 22 lordship.
The dates
This is
are
also
the
scheduled
same?
cost.
The
Date
dates are
also
also
same
the
lordship.
same?
Also same order lordship.
Who is
Ground is
appearing?
same.
State? Who is appearing
Rejection-
for the state? Where is the memo impugned?
Lordship, page 17.
Who is appearing for the state?
Similar time.
The same order be passed?
Yes.
Same as 22. In affirmative.
Lordship, my appearance should be recorded. I have already given in chat box lordship. Great lordship.
Online gulo chat box এ রেখে দিয়েছি। Yes, next. Next.
Yes, Lord. 25 Lord, I will.
Yes,
25 Lord.
single
Again,
people.
PPO, Lord, interest, claiming interest and gratuity and area.
Who is appearing? State? 25, you are appearing, same order, single people.
Single, top single.
Next. Next,
26 lordship will appear for the petitioner lordship.
26 amendments. Milord, I am appealing for this.
2620. No, 26.
yes,
Lordship, this is also same as 22 and 24 lordship. Only ground is slight difference lordship. This petitioner lordship obtained the civil caste certificate from the state of Assam. Lordship will find page 18. Page 18, second paragraph. Impugned order. Date is same, authority is same lordship. Only this slight difference. Impugned order, second page lordship.
oh, and not from West Bengal.
Lordship. This is a silly ground lordship.
My lord, in this matter, my lord, I'm seeking adjournment. Mr. Shah is appearing. So, my lord, if there is any conflict, he is in court number 1. Mr. Shah. Will you pass over for 15 minutes, my lord?
Tuesday. Tuesday,
Lordship, kindly keep it on Friday, 11 lordship. Another matter already fixed lordship,
Tomorrow.
11 lordship.
tomorrow I
Tomorrow.
can't, tomorrow there are several matters, not tomorrow, Monday or Tuesday.
Lordship, Monday lordship. Let it Monday lordship.
On
Monday or
where-
lordship, next Friday lordship. Friday week lordship, already one matter fixed on item number 19. Friday week lordship.
Friday week,
Lordship, Friday week 11.
11.
I'm great lord. Great lords.
On
I'm great.
where of- 11th, please do not fix it, last day, I mean, I don't know. Come back on 10th,
Yeah.
one day earlier,
Lordship, kindly keep it on Monday lordship. Monday.
Monday.
10th lordship.
On pair
Lordship.
of the respondents, the matter is adjourned, let the matter appear under the same heading on 7.
Monday lordship. Great lordship.
7.
Yes, Lord. Single PPO, my lord.
Single PPO.
Single PPO.
Who is appearing, state?
Only, only area. Interest on area.
Who is appearing?
Milord, I am appealing for this.
Single PPO, let us
Yes.
discuss.
Ah.
Next, next.
27. Yes. Okay, revised proper 2019.
Revised 2019. State,
28.
revised.
Yes.
What is revised?
You are please,
Next,
29.
29 petitioner.
Lords 29 lordship appear for the petitioner lordship.
Yes.
Lord, this is a different case lordship. Although
Who
lordship
is appearing
selection.
for the state? Who is appearing? You are appearing? Yes. Yes.
Lordship, in this case, lordship, petitioner was also appointed for the applied for the Anganwadi helper lordship. But lordship, in the process initiated in the year of 2019 lordship, thereafter lordship, during after filing of the writ petition along with others lordship will find page 14 of the writ petition lordship. Petitioner filed a writ petition before this honorable court lordship. Honorable court directed the selection process to be completed afresh lordship. In terms of the order lordship, they have prepared a panel lordship. And that panel lordship, although the name of the petitioner does not appear in the as figured lordship, but lordship, the name of serial number 11 lordship in the said list, one lordship Afroja Banu, who has already expired lordship. Already his name was in the his name, her name already in figured. But lordship, I have made a representation before the authority. Lordship, though the Afroja Banu has expired, in place of that, my name, my candidate should be considered in respect of the deceased person lordship. I have made a representation lordship on 30th May 2023 lordship.
Yes. They are praying for consideration. It has been granted in favor of a dead person according to the petitioner. So the petitioner wants to take a chance and get into that post. Let the representation be considered.
Lords.
Affidavit of service. It is contained on behalf of the petitioner that pursuant to a memorandum issued by the Joint Secretary, Department of Women and Child Development and Social Welfare, Government of West Bengal, on 25th June 2006 for recruitment to the post of Anganwadi workers / helpers, the petitioner applied for the said post and on being found eligible, was asked to appear before the selection committee for the written test and the viva voce in 2010 and 2012 respectively. Stop. The selection process was not concluded and concluded, for which the petitioner submitted a representation before the concerned authority for considering her appointment to the post. Stop. The said representation not being considered, the petitioner approached this court in a writ petition being WPA 9641 of 2020. Stop. By an order passed on 22nd September 2021, a coordinate bench of this court directed the Principal Secretary, Department of Women and Child Development and Social Welfare to constitute the District Selection and Monitoring Committee, Kuch Bihar afresh, and complete the process of appointment of Anganwadi helpers in Kuch Bihar 1. The court further observed that in case all the vacancies were filled up in accordance with law, the available / empaneled candidates should be considered against the vacancies that may arise in future. Stop. In terms of the said order, merit list was prepared for the post and 11 candidates were selected under the unreserved category. Stop. One of the candidates, one of such selected candidates, Afroza Basu,
Banu, BANU.
Afroza Banu,
Lords.
expired on 5th November 2020, resulting in the said post falling vacant. The petitioner submitted a representation before the concerned authority requesting consideration of her name in the said vacant post. Authority open date on 30th May 2023. Requesting consideration 30th May 2023 post, which is yet to be considered. In the said vacant post, which is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that who should consider? The seventh
number seven.
respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the seventh respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 2 weeks, within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week there. Disposed of.
Great, Lords.
Next.
Yes. Yes, I am for the petition. Here, my lord, petitioner is the widow of the deceased employee and my lord, claiming for interest and gratuity under revised ROPA 2019.
Yes. Revised ROPA. Widow.
No. Legal. Yes. There is single PPO, my lord, claiming interest on area. Single.
Mr. Shah? Single PPO?
Single area. Yes. my lord. Single PPO interest on area. Yes. Interest on area pension and gratuity. Yeah.
Gratuity also?
Yes. Petitioner is the high school. Yes, my lord. Single PPO, my lord, interest on area. Single.
State? Hello.
Area. Page 11. Yes. Single PPO Miller, select on area.
State. Yes.
Certified for the same, select on area. Single. Certified. Solo PLB.
State. Mr. Shah. This one.
Same Miller, select on area. Single.
State, Mr. Shah. Next.
Yes. Single PPO Miller, same Miller. Select on area.
Mr. Shah and this one. High school assistant teacher, not head teacher.
Assistant.
Here it is head teacher. You have not made the corrections properly.
Miller, corrected order.
Where corrected order? No. We have not corrected it.
All are assistant teacher. High school teacher.
Join the, we will show our assistant teacher. Here.
High school teacher.
Repetition. Take it.
Your Lordship, may I please, I am for the petitioner in this matter. Lordship, we've already effected the service, but as far as respondent number 3 and 5 are concerned, we are not, the delivery report has not yet been there.
So will
It
you
has
come
not-
back next week or?
Lordship, if I beseech your Lordship, if the matter can be fixed on 8th of August, Tuesday.
Very well, come back on it.
Deeply obliged, Lordship. Grateful.
Since service upon all the respondents is not complete, comma, let the matter stand over till 8th August.
And 40.
Next circuit,
No, it's on Tuesday. You will be here on Tuesday.
40,
39 and 40.
39 and 40. State. Nothing. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8. 39 and 40, same on.
Yes.
Petitioner. 41 petitioner. None appears for the petitioner. No accommodation is sought. Paragraph. Let the matter appear. Petitioner. Get it. Yes.
Lordship,
A report was called for.
no Lordship, no compensation paid to the petition.
You have
Lordship,
paid for-
actually, Lordship, his grievances was the Panchayat authorities encroach his land, but nothing was remaining. Lordship, actually, his land was back to him in the pre-existing condition. Lordship, that was in the previous report. I would like to submit the report in the affidavit from Lordship. Kindly allow me 2 days accommodation, Lordship.
Wednesday.
Monday, Lordship.
when several matters are on Monday, very soon.
Lordship.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 9th August.
Lordship.
Lordship, the petitioner before your lordship is an employee of Canada Bank. He is working as an assistant temporary attendant.
Who is appearing for the respondents? Your matter was restored.
Lordship.
After that, have you served notice?
After that, I have not.
If you serve and come back. Next circuit,
Monday, lordship. Yes,
not everything cannot be done on Monday.
because lordship, in this matter, identical matter, order has been passed by the division bench, interim order. So I am paying for similar order. Lordship, kindly see page 84, 85.
You serve and come back, sir.
Lordship.
Otherwise,
Then
not.
Monday, lordship, because very small matter.
Since a service upon the respondents is not complete, comma, let the matter stand over till 9th August.
Yeah. Lordship, I am for the petitioner. Lordship, I am fearing for not this week, Lordship. Lordship, not today this matter.
Not this week means next circuit, right?
Lordship, this matter have some urgency. Lordship. This matter also pertaining to land acquisition, Lordship. And
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 10th August.
Lordship, grateful, Lordship.
Hmm? 44, anyone? কেউ আছে কি? Virtual mode কেউ আছেন? No? None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. Yes, anyone? He mentioned it. Mention. Anyone for the petitioner? None appears for the petition, same order as the earlier one. Next circuit. Nearly. শুধু none appears for the petitioner বলছি। State গুলো রেকর্ড করতে নামগুলো। না, just নামগুলো।
I appear for the petitioner, my lord. My lord,
Served.
yes, with the lordship's leave, my lord, can he place it?
Absolutely, why not? Yes.
In this matter, Mr. Raman is appeared. He's down, very down. He's suffering.
So you need some time.
Yes.
10th.
Yes.
On prayer of the respondents, the matter is on 10th, you please make your submission. He'll do it, yes. On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 10th August. Yes.
My lord, this is against seizure of goods, my lord. And my lord, they were
You wanted to file a short reply or something?
no, my lord, they were to they took the on the last date, my lord, they took the adjournment to take instruction, my lord. If I'm not wrong, my lord.
Yes, the respondent wanted to come back with a
My
report.
lord.
Mr. Ghosh,
The report is not ready, my lord, yet.
next circuit.
Not as he wished.
Yes, Mr. Ghosh, next
It is
circuit.
a very, very short issue, my lord, that the place where the goods were seized, my lord, it was already incorporated in my registration certificate. But they were getting inspected whether the certificate was, that godown was appearing, which was appearing in the certificate was correct. This solved all the issues.
So let me come back with the report, my lord. Grant me, my lord, a week's time, my lord, next week probably. my lord.
Week's time. So next circuit. Learned counsel for the petitioner seeks, learned counsel for the respondents seeks accommodation to submit a report in the form of affidavit in this matter. Paragraph, the matter be placed before the next available circuit bench. Next.
My lord, 48, my lord, I think again, there will be an adjournment.
Why do you-
In this matter, my lord, I seek a adjournment. my lord.
Instruction আছে
Next.
আমার। Instruction
Next
আছে, তুমি বলে করতেছি। Instruction আছে।
My lord,
On
next.
prayer of the parties. On prayer of the petitioner, the matter be placed for the next available circuit bench. Petition.
Thank you. Lordships, this matter are list of documents and chronological. It's
Have you given a copy?
Lordship,
Just now.
Just now. It's all right.
all facts is undisputed, your lordships. The earlier.
একটা কপি আছে না তোমার কাছে? এই রিপোর্টটা, হ্যাঁ। দাও তো, এটা দিয়ে দিন। আমাদের রিপোর্টটা রেকর্ডে থাকুক। এটা দাও। রিপোর্ট নাম্বার বলো তুমি। 353 পেজ।
সুব্রাসমের অর্ডারটা হলো 342 59 থেকে 59 টু 59 টু 59 টু 63 সুব্রাসম। আর তারপরে একটা স্বামী চক্রবর্তী আছে, একটা সুবল ভট্টাচার্য আছে।
ঠিক আছে।
Yes, let the same order be passed in terms of the earlier petitions.
But I have a report, let that be taken on record. My instruction and report.
What is your instruction?
My only instruction that is differing here is before joining in 1981, the kindergarten school was private. It was not taken over by the government bank. It was taken over by the government on 88.
That is the case in all the
It's
cases.
already settled.
They are friendly, I'm just.
Series of judgments.
Just for the sake of it.
Even in my report also it says that.
Yes. Series of.
Oh, that is said
There is
there.
also said, yes.
Series of.
Court's order, there is no question.
Now, Anna,
Subrasham matter is long matter.
The petitioner Was appointed as she was a teacher.
Lordship retired as a teacher, but at the time of joining, say joining as a group D staff.
The date of appointment is 3rd August 1981.
Yes, Lordship. Joining date 3rd August
The
1981.
petitioner was working. The petitioner was working in Shishu Mahal KG unit since 3rd August 1981. Stop. The school was initially a private school and was taken over by the District Inspector of Schools within bracket primary education bracket closed, comma Jalpaiguri on and from 1st April 1974. Stop. The petitioner has been receiving salary since August 1981 as per government scale. তো একদম শুরুতে একটা লাইন করুন তো particulars submitted by the petitioner and reports submitted on behalf of the respondents are taken on record. একদম শুরুতে first line. হ্যাঁ 12 teachers were appointed.
Lordship, in one memo, your Lordship, 12 teachers and 8 non-teaching staffs were appointed on 31st July 1981.
Yes. 31st July 1981.
Issue of memo, your Lordship. Then subsequently they joined in 3rd August. It is found, your Lordship.
No, 8 teachers were not approved. Where is
Yes,
that?
in 1988, government says the 4 teachers were say strength vacancies, so they are appointed. Now, the rest of others, regularized their post, but they did not claim the area salaries in 1988 memo, Your Lordship. Now subsequently, this memo also challenged before this Honorable High Court. That this writ petition allowed and the government issued a memo, the writ petitioner is entitled to get area salary also. I have annexed this memo. That memo, Your Lordship.
Page,
Your Lordship. 38, 39, Your Lordship. Page 38, 39. Last portion, Your Lordship. However, in view of the decision of the Honorable Court, it is directed that such approval of the appointment to the petitioner be accorded with effect from 3rd August 1981 without insisting on such undertaking being furnished.
the Deputy Secretary, please correct me if I'm wrong on the factual aspects. The factual aspects are a little complicated. The Deputy Secretary, Education Department, Primary Branch, by a communication dated 29th January 1988, intimated the Director of School Education, Primary Unit, regarding approval of appointment of 8 teachers who were,
My lord, if I may, my lord, one indulgence. And
Yes.
in my report, my lord, that is clearly there on my
Yeah.
second page. My lord, it is
Bottom,
from the Deputy Secretary to the Director of School Education.
Hey, respondent number 5.
to the Director of School Education,
Oh,
Primary
yes,
Unit.
right,
Yes.
right.
একটাই তো পোস্ট, ওটাই হাইয়েস্ট পোস্ট। এটা এখন কমিশনার হয়ে গেছে। এখন কমিশনার হয়ে গেছে।
কি বললাম একটু আগে বলে দিই। হুম। Appointment of 8 teachers. In the existing vacancies, who were permitted to draw their salaries from government fund without claiming any arrears. Without claiming any arrear of pay, and a written undertaking to that effect was called from them. Appointment of the remaining 4 teachers who were appointed against the normal vacancies was approved. This order was challenged. Page 59 is the challenge. This order.
This order challenge, Your Lordship, page 38, 39.
That is before the Director of School Education. A writ petition was filed.
Writ petition was filed. That subsequent on the basis of order of the Honorable Writ petition, respondent number 5 issued this memo, Your Lordship.
The order was challenged by one of the teachers before this court. And before this court in WPA 342 of 2019.
Lordship,
No, this is not the one.
Lordship. In 1988 memo challenged by one of the teachers. Now, on the basis of that memo, Lordship, respondent number 5 issued this memo, Your Lordship.
Challenged by, challenged
39.
in the writ petition.
Yes, 38, 39 page, Your Lordship. Now, subsequently, series of incidents happened. In SUVRA matter, Your Lordships, kindly see improved memo 2017 one memo. 2017 memo, Your Lordship. Subsequently, all teachers retire and they get retrial benefit from the date of joining. Now, in 2017, respondent number again issue one memo. That is the next year, Your Lordship. That is memo number page 58. In Annexure P10. This memo was challenged in SUVRA matter 342 2019, Your Lordship.
To get pay fixation from 1188. So you're
Yes,
asking
yes,
for one.
yes. It's say issue a memo and say that all the teachers and others teachers they get benefit from 1988. Now this memo was challenged by SUVRA in 342 2019. Now in that order, Your Lordships, Honorable Court allowed the writ petition and directed you to give all the benefits, calculating pay scale and others from date of joining. I have just annexed earlier order, Your Lordship, that is 1991 also one writ petition allowed.
Where is that writ petition?
Writ petition I am not annexed, Your Lordship, already.
So pursuant to that writ petition, this page 38, 39 memo was passed.
39 memo was passed on the basis of earlier writ petition. Now 2017 again page 59 P10 was issued. Then that was against that memo is also challenged in SUVRA matter, Your Lordship.
So in the earlier writ petition, the first writ petition, there was a direction for appointment to be accorded with effect from 3881, not
Yes.
1.
Yes, 81.
3881.
Yes, all that
Without insisting on undertaking.
Lordship.
আচ্ছা এই লাইনটা কেটে দিন এই রিপিটিশনের লাইনটা কি বলেন চ্যালেঞ্জ কেটে দিন এই লাইনটা pursuant to, that's why I said please mark what I'm saying.
Yes, Lordship.
Pursuant to, there are several writ petitions, several
Lordship,
orders.
Lordship. In this
Pursuant to a writ petition, pursuant to an order passed by a coordinate bench on 10th September 1990 in CR number 10029 within bracket W bracket closed of 19. It is again not legible. The number page 38.
3891, Your Lordship. July 91, Your Lordship.
No, CR 10029 of
1990, Your Lordship.
1990.
Lordship.
1990.
Jaya Dasgupta versus State of West Bengal.
Yes.
That's it.
The School Education Directorate issued a memo dated, this is 9th July.
Order dated, Your Lordship, the first line is 10th November 1990. The case is taken up for hearing today in pursuance of the solemn order dated 10th.
No, the subsequent memo, page 39, it is 9th July 1991, the memo.
Memo is
Pursuant to the order.
1991, July 1991.
9th July, what is the date?
Your Lordship.
8th July. July 1991. Granting approval to the appointment of Joy Dasgupta was one of the teachers.
Lordship, Joy Dasgupta, one of the teachers.
Granting approval to the appointment of the petitioner therein, namely Joya Dasgupta, with effect from 3rd August 1981, without insisting on an undertaking to be furnished, without insisting on an undertaking being furnished, where is the subsequent memo which was challenged later on?
Later on, your lordship, P10,
Page,
58.
stop. Subsequently, a memo was issued by the department on 24th November 2017,
Lordship.
in clarification of the pension cases in respect of the school, wherein it was stated that the teaching and non-teaching staff of the school were entitled to get pay fixation benefit with effect from 1st January 1988. Now, this memo was also challenged
Yes, yes, lordship.
by SUVRA Shom.
SUVRA Shom, your lordship.
This memo was challenged by one of the teachers, SUVRA Shom, SUBHR, SOM, in a writ petition being WPA 342. 342 of 2019, and by an order passed on 29th August 2019, a coordinate bench of this court
Relevant motion order 63, last portion.
relied on the doctrine of, within bracket, equal pay for equal work, it inverted comma, number, and allowed the writ petition directing the concerned authority to issue necessary direction for disbursement of all benefits in favor of the petitioner therein, taking the scale to be effective from the date of her joining service, that is, from 3rd August 1981, with the only exception of the arrears of salary prior to 1st April 2003. A similar order was passed subsequently.
Lordship, Sami Chakraborty is a similar order. Like,
And you are praying for the same order.
SUVRA Shom, that is Subal Bhattacharya, is a revised PPO memo. Already on that writ petition, lordship, memo number 633/26/2005, that is page P4, page 36. Now, last portion has also set aside in Subal Bhattacharya order, sir, lordship. This memo,
Where is that order?
lordship. Subal Bhattacharya. Page 76, your lordship. Page 76, your lordship. Relevant portion, page 78. Lordship, page 78, first, dispute the applicability of the said decision of the fact of the case in view thereof the portion of the order dated June 2, 2005, issued by the chairman, District Primary School Council, Jalpaiguri, that the monetary effect will be given retrospectively from 1st April 2003 is set aside and quashed.
Page 78.
78, first portion.
Where is this June 2, 2005 order?
That is page 36, 37. P4, 37, last portion.
This part was dealt with by the, in the writ petition also.
Lordship,
the
1728,
Shubhra Shom
2022, Subal Bhattacharya versus State of West Bengal.
Because this 342 of 2019
Same with the
says,
continuance.
with the only exception of
Yes,
8 years
yes,
of
yes.
salary.
On that time, this memo is existent. This part, set aside by 1728 of
Later on.
subsequently 2022.
In a subsequent decision taken in WPA 1728 of 2022 on 13th July 2022, a coordinate bench of this court set aside the portion of the order dated 2nd June 2005 to the extent that monetary benefit will be given retrospectively from 1/4/2003. This part was set aside. Paragraph. Other assistant teachers similarly circumstanced with the petitioner filed several writ petitions before this court seeking retirement benefits from the date of their joining the school. That is your claim.
That's right.
It appears that there is no dispute with regard to the date of joining and the date of approval of appointment of the petitioner. The appointment of the petitioner was approved from 3rd August 1981.
Yes.
From 3rd August 1981. Stop. Paragraph. In view of the judgments passed by coordinate benches of this court in the earlier writ petitions, and also in view of the fact that the petitioner herein is similarly circumstanced with the petitioners of the earlier writ petitions, this court is inclined to hold that the petitioner is entitled to all her retirement benefits with effect from the date of her joining service and cannot be discriminated from the other teachers who have been directed to receive such benefits by this court earlier. Paragraph. In view of the above. Anything else?
No, no.
In view of the above, the writ petition is disposed of, directing
Let's see, respondent number 2, 5, 6, and 7.
2, 5, all of them.
Lordship,
of them.
one of the main, your lordship, director of the school education, that a commissioner, director of the school education, West Bengal, respondent number 5. District inspector of school, that is respondent number 2, your lordships.
They're all in the loop actually.
Yes,
Respondent
Lordship.
number 5 is directed, he's the senior most and he can direct
Yes,
his junior.
yes, yes.
So let 5 be directed.
Let's,
Yes.
let
Five.
take it.
Directing the 5th respondent
Commissioner.
Nah, DIA এর rule থাকে তো।
তো ওই তো
To
subordinate, order to
take necessary steps
Prayer F বলেছি।
for disbursal of
Lordship, my prayer F, your Lordship, is specific, respondent number 5. Read mandamus directing the respondent 5 to issue direction to the respondent number 2, 6 and 7 to pay the all retrial benefit, gratuity, pension, etc. of the petitioner calculating his art service from the date of his joining. Respondent number 5 issue the direction sort of practically.
Well, directing the in terms of F,
Yes, madam, no.
directing the 5th respondent to issue necessary direction upon respondent numbers 2, 6 and 7
কেন তাই তো?
to disburse all retirement dues, including gratuity, pension, etc. of the petitioner, calculating his service from the date of his joining,
Hard service.
that is on 1st August 1981.
Let's
Stop. The entire exercise is expected to be completed within 2 months.
Yes, ma'am.
Within 2 months from the date of communication of this order.
Not to one indulgence, hard service. My mistake, I'm recording his service, hard service. The lady,
Oh, she's a lady.
hard service.
Grateful.
And let's see, issue revised PPO. Your Lordship. In this case, one PPO had already been issued. So it is a revised PPO. Your Lordship.
Since PPO has already been issued in favor of the petitioner, the authority is directed to issue revised PPO within the stipulated time frame.
Let's get
Disposed of which act? Next.
Item number 14 is clearance now.
Lordship, item number 50, here for not today.
Not today means next circuit. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 10th August.
Lordship, 51, 52 also.
50, 51, 52. Same order. No? Petitioner is asking for time. 10th August. 50, 51, 52.
Lordship. Item number 50, I am for the private school.
50, give your name. She's asking for adjournment. Give your name. Next. Same order.
I pay for the writ petition also. This writ petition,
Yes.
I'll tell you, Lordship, my lord, this has, my lord, traveled to earlier circuits. I am before this honorable court praying for a re-evaluation of the marks given to me in respect of a
Who is
particular
appearing for
question.
the respondents?
Vikram Chilwar.
53.
My lord, if it is Mr. Ghosh was appearing, my lord, he is in court number 1.
Yes, that I have seen. Mr. Ghosh is there.
And seeking adjournment.
On prayer of the respondents, state respondents, the matter is adjourned. Let the matter appear under the same heading on, when will you come back? 9th August.
There is a lordship.
I'm for the petitioner, my lord.
I beg to appear for the state lordship.
Yes.
My lord, there is a subsequent application, can application, my lord. But here is.
The sole petitioner
Sole petitioner, my lord.
within
During-
time,
Within time. During the pendency of the petition, petitioner expired. My lord, on a last.
you
docket-
filed the application within time.
My lordship, my lordship.
When did the petitioner expire?
My lord. Annexure P1 is a death certificate, my lord.
9th April. Yes. Let this be
Yes,
allowed.
Lordship.
My lord, on a last location, my lord, on a same issue, a bunch of matter has already been disposed of by this coordinate bench because the petitioner is the ex-employee of the HIMUL. So my lord, the order will be same. I have the order.
What is your prayer?
My lord, I am asking for the interest upon the gratuity because the petitioner retired on 30th April 2012, but the gratuity paid on 2018. So it is a delay of 6 years, my lord.
You asking for interest on gratuity?
Interest on
Yes,
gratuity, my lord.
Not
made some-
necessary. I have my own orders.
Oh, my lordship, my lordship, my lordship.
Interest on gratuity. Taragi Can 1 of 2023. The applicant prays for substitution in place of the petitioner who expired during pendency of the writ petition. Paragraph, the application has been made within the statutory period of time, Paragraph, the application being Can 1 of 2023 is allowed. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, over WPA order. It interest on gratuity order. Single people. Single people should do paragraph at present during pendency of the writ petition. The petitioner has expired and his wife has been substituted.
My lordship.
And
He's
his
the legal.
wife has been substituted in his place. So what order to present upon petitioner only for present petition. Today I have the fact. Next.
56 and
Yes, sir.
57, Madam. Mr. Bhumi Rahman is appealing for the respond number 3 and 4, Madam.
Yes.
It's suffering from high fever since yesterday, Madam. If you can keep the matter on Tuesday, next Tuesday. He was supposed to submit a report, Madam, on the college, Madam. The matter is based
Next Tuesday. On prayer of the, you are appearing for the private respondents.
No, respond number 3 and 4.
On prayer of respondent numbers 3 and 4, the matter is adjourned. Let the matter appear under the same heading on 8th Tuesday.
Well, the report may be filed.
Yes, please. Please serve an advance copy.
Yes.
56 and 57,
Sir,
same order.
yes, my lord. Yes, my lord.
You're 3 and 4 in both the matters.
Lordship, I'm for the petitioner, praying for not today, your lordship.
Not today, difficult. On prayer of the petitioner, the matter is adjourned. 58, Worship. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th August.
Lordship. 59, Lordship, I am for the petitioner.
Lordship, I seek for adjournment as the learned additional advocate general will appear in this matter, Lordship. He is busy in the court number 1, Lordship. Kindly fix the matter the next week, Lordship.
This is a public interest litigation. There has been an order. I
Yes.
cannot deal with, this court will not deal with. public
Yes,
interest.
Lordship.
No, there is special finding.
There's a specific finding by a court.
I am appearing before your lordship on the strength of a order.
There is an order, sir, I cannot help. In view of the observation made in the order passed on 6th June 2023, the matter be released from this list.
Use my affidavit to submit.
My lord, in 60, I'm appearing on behalf of the private respondent. I'm not sure if my lordship. if your
Why was
lordship
the
can
matter
hear me.
released for want of determination?
Because in the previous circuit, Justice Sengupta was taking determination from group 1 to group 4, and this pertains to municipality.
Circuit determinations are not divided like that.
No, in the previous circuit, justice, in one circuit it was.
It was done like that.
Yes, the justice.
Am I audible to your lordship?
Yes, you are. You're appearing for?
I am for the private respondent, your lordship, respondent number 11. I'm paying for dismissal with costs. My lord would kindly hear me at the appropriate time. I'm paying for costs in this matter.
You're praying for costs even without submission?
My lord, no, I want to submit on cost. My lord, I want to submit on costs because not only is this a public interest litigation, this matter has been filed with suppression of fact. A public interest litigation on the same cause of action had been filed before the Honorable Chief Justice. That was dismissed for non-prosecution. That has not been mentioned. And there's perjury because the petition, which has been affirmed by the petitioner, states that no other petition on the same cause of action has been filed. So not only is this a public interest litigation, my lord.
Lordship kindly comes to page 107 of the petition.
Public interest litigation was filed
Yes,
on the same issue?
this was an order passed in the public interest litigation. And the order was that to guarantee an opportunity of hearing with regard to my representation cost to the respondents. Lordship, a opportunity of hearing was granted to me and the result order was passed. But subsequent to that, if your lordship directly comes to my
Public interest litigation has been disposed of.
No, my lord, thereafter another public interest litigation was filed. This is WPA, the first public interest litigation was 9554.
No, 16160.
16160, which was, I mean, it's the same petition, my lord, the numbering was different. Thereafter, the petition was disposed of with the directions that the district magistrate would deal with the complaint. The district magistrate dealt with the complaint, found that the allegations were baseless and passed a reasoned order. Thereafter, the petitioner goes ahead and files another PIL numbered as WPA 18 of 2020. My lord, I am assisted by the local council. This fact has not been mentioned. It's exactly this reason why I am praying for costs, my lord. This fact has not been mentioned. I'm assisted by the local council who will hand over, my lord, the case status of WPA 18
Who is
of
here?
2020.
Who is representing the, you are representing?
My lord would kindly look at the petition in WPA 18 of 2020. It's a copy paste. That was the first petition. So that was the PIL that was filed, which has not been mentioned in this writ petition.
Where is the petition? Yes, what do you say?
Now, I do to take instruction with what he is submitting, but here I am on a different. My subject matter is that a reasoned order was passed. I have an opportunity of hearing was granted to me. A reasoned order was passed, and
It
in
is
that
said that pursuant to that you filed another PIL on the same issue.
That with that lordship, I don't have any.
Next circuit.
My lord would kindly hear me for 1 minute, my lord.
Next circuit. He wants to come back with instructions.
Very well, my lordship, please.
He's made aware. Let him come back with instructions.
Lordship, please. Lordship, please.
Lordship, in that case, kindly please any day next week, lordship.
No,
no. I shall take
next circuit. Take instructions and come.
Grateful.
Grateful to your lordship.
Affidavit of service. On prayer of the petitioner, the matter is adjourned. Paragraph that the matter appear before the next available circuit. Next.
My lord, 61, I am appealing on behalf of the petitioner, my lord.
My lord, before my lord takes up the matter, my lord, in this matter, learned advocate, additional advocate general is appearing. He is report number 1. It's a matter regarding execution of lease.
My lord, execution of lease deed, my representation has not been considered. My only prayer, my lord, my representation may be considered, my lord. I have already paid the amount. Lease has not been executed.
Let it be disposed of.
My lord, since London additional advocate general is appearing, I cannot make a submission regarding that matter.
And my only prayer is to consider my representation.
Monday.
My lord, tomorrow, my lord, if possible, my lord.
Not today.
Yes, yes.
Yes, 62. Affidavits were called for. Where is your affidavit? Yes. And where is your affidavit of service? Who is appearing for the petitioner in this matter? Anyone appearing for the petitioner? None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench.
Shiva, I beg to appear for the petition.
Lordship, I seek for adjournment, Lordship, in this matter as the learned counsel Mominur Rahman, he is ill, Lordship. He is suffering by the viral fever.
Next circuit,
Lordship.
Any day in the next week, Lordship.
next circuit, she's asking.
It
On
can be
prayer of the
about-
respondents, the matter is adjourned. Paragraph, let the matter appear before the next available circuit bench.
Lordship, I am on behalf of the petitioner in item number 64.
I am for the state, Lordship.
Lordship, this is my affidavit of service, Lordship. May I proceed, Lordship?
Yes, only state respondents?
No, Lordship.
There is
GTA
Gorkhaland
also-
Territorial Administration also.
Who is appearing? Have you served?
Yes, Lordship. To both the respondents, state respondents and also to the GTA, Lordship.
You are for 2, 3 and 4.
Lordship, I am for the only state,
Respondent 4.
Education
respond number 4,
department.
Lordship.
Yes,
Respond number 4, Lordship.
what about 2 and
Respondent
3?
state আছে? GTA আছে, state আছে? नहीं, 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 private नहीं. Lordship, the matter is that, Lordship, the petitioner is working as teacher in charge of a government aided school, which falls within the territorial
You
jurisdiction.
served the learned counsel, not even the party. Learned advocate for GTA has received. You
Lordship,
serve the GTA. Why learned advocate? How do you know that he is appointed in this matter?
because in all these matters, she appears for the
serve the
GTA
party,
and she
sir.
has already appeared, Lordship.
Yes.
Miss Supriya Singh,
Yes, Lordship. She has already
She used to
appeared
appear
in this
for the
matter,
GTA, Lordship.
she is the only advocate who appears for GTA.
Yes.
Lordship.
And what about the service on 2 and 3?
and
Respondent
3
numbers 2 and 3.
2 and 3, Lordship, are represented by GTA. They are the authorities of Gorkhaland
Oh, very
Territorial
good, very good.
Administration, Lordship.
But I do not find it.
Because generally, my lord, PTA appears, my lord, and.
You are appearing for the petition
No, my lord, for the respondent.
for
Respond number
GTA.
4, the
Not GTA, my lord, Supriya Singh is the, my lord.
So you are appearing for which of the respondents? You are appearing for 2 and 3. Next circuit,
No, Lordship, I am only praying for representation and reconsideration, Lordship. And in this regard, there are several other orders,
next
Lordship.
week, let Miss Singh come back.
If this,
Please inform. On none appears for the first affidavit of service. None appears for the first respondent despite service. Paragraph on prayer of respondent numbers 2 and 3, the matter is adjourned. Paragraph, let the matter appear under the same heading on 10 August.
let's fix it on Monday.
Monday, several matters are fixed.
Obliged.
My lord, I am appearing on behalf of respondent.
Yes,
65, I'm appearing for the petitioner, Lordship.
yes.
My lord. My lord, before Lordship once again goes into the thicks of the brief, my lord, the whole crux in this issue is whether the government be permitted to take the advantage of its own wrong. What has happened here, Lordship will see, there was an adjudication order dated 8th of February 2022. I'll refer to the brief, my lord, just I'm narrating the in nutshell the facts. Adjudication order was passed on 8th February 2022, but peculiarly enough, that was neither uploaded in the portal nor the notice of demand along with the adjudication order was ever served upon me. So without the order being uploaded in the portal, the link to file appeal does not activate. I waited. I made them several communications.
Give you a minute, please. Who's appearing for the state? Where is your affidavit of service?
My lord, in the last occasion, I had
Appearing on behalf of CGST department.
Yes, what about the?
CGST is the answering respondent, my lord.
Yes, but you have to serve
My
all
learned
of
friend
them.
is, my lord, I
You
have
serve
served.
all.
Unfortunately,
There
my
is-
lord, I am having the affidavit of service with me because
Anyone
it has.
appearing for the state in this matter?
Lordship, generally in this matter, Mr. Subir Kumar Shah, AGP and Vikramaditya Ghosh will appear, but
Yes, but
both of them are busy in the court number 1, Lordship.
But they have
I
nothing
have
to
their
submit, my lord. My lord, they have nothing to submit.
their
Last occasion,
presence, when you
my
have
lord, they only
implemented
said.
them,
My lord, they only said in the last occasion.
when you have implemented them, their presence is necessary. I do not even have the affidavit of service with me. Please
Lord, may
come
I-
back next week.
My lord, may I humbly submit one thing, subject to correction, my lord. In the last 2 occasions, the state, Mr. Vikramaditya Ghosh, he himself submitted, they have nothing to submit on this. And my learned friend, Mr. Bonik, he was the answering respondent, he himself submitted that as well. He took time in the last 2 occasions, so the matter could not be heard out. I
One
think this will
occasion.
be corroborated by Mr. Bonik as well, that SGST.
Short adjournment for 10 minutes.
Only one,
Just
on
yesterday.
one occasion, adjournment was sought.
Just 10 minutes.
No, my
On
lord,
31st,
yesterday, not today was granted by the instance of my learned friend, Mr. Bonik.
Yes, but I do not find the state's representation at all. Please send the affidavit of service in the meantime.
My lord, may I,
And let the state appear.
may I put it in the
There
chat box?
should be someone for the Union of India also.
No, my lord, the Union of India is, yes.
Union of India is not the, yes, Union of, yes, we are appearing.
You are appearing.
Yes,
So only the state
CGST
needs
and
to,
Union of India.
only the
Yes.
state needs to be
Only the
represented.
state.
Come
My
back
lord, may
next
I,
week.
may I submit the affidavit of service in the
Please
chat
do
box
that.
itself? In the chat box itself right now?
Can't you, can you send it to someone?
My lord, in the course of the day I can?
So
the
let it
course of the
appear on, let it appear on Tuesday. Please come back.
My
The
lord,
state
Monday
is
will
not
be,
there. They
Monday,
need to be there.
my lord, Monday will be of great help if your lordship kindly takes it up on Monday.
Come back on Monday. Monday, several matters are there.
Lordship
On
will
prayer
kindly
of,
do a.
Monday, I have a small submission. Monday, after 2 PM, it will be better.
it will be called. Let us see. Ah.
No.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on Monday is 7.
7.
7.
7th lordship.
Grateful.
Grateful to my lord.
I beg to appear for the state Lordship.
My lord, can you recollect it is that matter where the my complaint was not registered under the scheduled caste and scheduled tribe atrocities.
Yes, yes.
My lord, that put 2 queries, my lord. First, whether the accused belongs to these categories and whether the chief judicial magistrate can I can ventilate my grievance before the
This
learned
court, yes.
before the learned, will that be the proper forum, my lord? My lord, the accused, my lord, I have taken instruction belongs to the general category.
General category.
Lordship, I also inquired the matter. It is fact, Lordship. Yes.
General category.
Now, with regard to the next point, my lord, I could not prepare myself. My lord, I have quite a few today. If your lordship takes it up
Because
any.
in all probability, I think you can make this submission before the concerned court.
My lord, what is, my lord?
That is what we used to do when we were in a criminal determination or even in the district judiciary.
But my lord.
When there's an application for addition of section, a report is called for from the IO.
Yes.
And
my
upon
lord-
perusal of the CD, it is added.
But if had it been registered under the special act, the IO would have been different. The IO would
I
have.
understand, but the present IO is progressing with investigation. He
Yes,
is conducting an
yes,
investigation.
my lord.
So that will be produced before the CJM. The CJM will
Yes.
consider that and send it back. There is a provision in the CRPC
May I
actually.
come back next week,
Yes.
Malad, on this limited point?
In case of higher provisions, there is a provision where it can be sent.
Yes, higher provision, I get your point, Malad, but this
Yes.
is a completely separate.
I do not
act.
exactly remember the section, but there is a provision which says that if you
Yes.
want to,
But subject to correction, my lord, whether that inclusion of other sections, yeah, I think is it done after the investigation is completed?
because I believe the writ court cannot help you in this. I
I
cannot direct inclusion of a section.
not section of an
Yes.
act, because here, my lord, I am.
The
on a-
act, the
Yes,
act,
I
right.
understand, but here
The
I am on a
Atrocities
point,
Act, yes.
I am on a point where, my lord, a statutory mandate has not been followed by a state respondent. My grievance is that the
You have
moment,
to
my lord,
approach the state respondent. Come back, come back.
I'll come back next week, my lord. I'm sorry, I have to
No,
take,
sir.
but I could not. 10th.
On prayer of the petitioner, the matter is adjourned. Paragraph.
My learned friend will not be here from.
Till from 9 to 13, I will not be available. Lordship.
Sir, again,
So eight,
Eight.
let the matter appear under the same heading on 8.
I beg to appear for the petitioner, my lord.
Yes. Have you served a copy of the supplementary affidavit?
Yes, ma'am. My lord, the matter relates to transfer of a BSF personnel from Siliguri to first Guwahati, and thereafter, my lord, during the hearing, at the time of hearing, my lord, they have come up with another transfer order which says that the petitioner has been transferred to Gopalpur, Kuch Bihar. So this supplementary affidavit relates to that. I have challenged that transfer order in this supplementary affidavit, my lord. Now, my lord. May I take your lordship to page 38 of my petition, main petition, my lord. Page 36, annexer P6.
What is your prayer?
My lord, I have prayed for 1 year extension of my to state the transfer order for 1 year, just 1 year, because my daughter is disabled, 60% disabled. I have annexed all the medical document of my daughter. My wife is a cancer survivor. So I am the only caregiver of the family.
Challenge the earlier transfer order.
Yes, my lord, in this writ petition. Thereafter, at the time of hearing, my lord, they have come up with another transfer order. During the pendency of the writ petition, they have issued another transfer order, and that order has been challenged in the supplementary affidavit. Because that order cannot sustain, as because that order specifically states that all SCGD, head constable, general duty shall be transferred. But the
You
transfer
wrote
order
for
issued on
category.
26th of June, and petitioner was promoted to the post of assistant sub-inspector on 8th of June.
So this
Before-
order was issued prior to your promotion.
Subsequently after my promotion. And the order specifically states, may
You are at serial number?
my lord, at serial number
The last order?
34, my lord, page 12 of my
Yes.
supplementary affidavit. Now, my lord, kindly see page 13.
Of your repetition.
No, my lord, the supplementary affidavit.
Yes.
The above SCGD be relieved for their new place of posting at the earliest, and compliance be submitted to all concerned by 27 June 23. Now, these are issued on
24th June 23. This order was issued on 24th of June 23.
Yes.
Now, my lord, come to page.
And what is your post?
Right now, my lord, I am promoted as assistant sub-inspector.
On the date of order?
Yes, my lord. On the date of order, I was assistant sub-inspector, not
Not the head constable.
not head constable. And why, ma'am, why I'm stating that if my lord sees page 18 of my supplementary affidavit.
Yes.
I number such and such, SCGD now ASI GD Lal Babu Rai.
10th June 23, you've assumed charge.
Yes, my lord. Thereafter, my lord, after getting this transfer order on 6th of July 2023, I made another representation before the DG BSF Frontier Headquarters, SDG EC BSF, and IG BSF, which is at page 19. I made another representation that my transfer, I just want 1 year because my daughter is under treatment before
Let
the
the
CMC
authority
bill.
explain how this order is applicable to you first.
Is there any allegation that has been promoted after?
No, no question.
The transfer order was made, it is the name, the post does not matter. Why, my lord? The movement order that was served upon him has refused to receive. Or the last one, or
That is the earlier order.
after, it is clearly mentioned, number 922067392, NCPT now ASI GD Lal Babu Rai.
Where is it mentioned?
I'm perplexed.
My lord, I would like to take a look.
So what is his demand? Does he fear that he will be demoted?
My lord, every time on the date of hearing, they are coming up with a new document.
Mr.
You have to provide a copy of that.
Let me
Kindly,
provide it. Let me finish.
kindly provide me a
Let
copy.
me finish. When you are submitting, I don't say anything.
No, no, every time on the date of hearing, you are bringing a new document.
But what is his claim and what is?
My lord,
his
kindly
claim?
see the date of the document. Kindly see the date of the document.
What is his demand? I fail to understand.
They have violated the central government
Please, please.
circular, my
You
lord.
He has been shifted to the post of,
Yes, I.
where is that stated?
Mother talk. There is no denial that he is ASI. He doesn't want to join in the new post of point of posting.
He sought a year's time for his daughter's treatment.
Lordship, his first ground was that if the Lordship was the early order, that he doesn't want to go to Guwahati, Assam. He was then re-transferred to somewhere near Kuchbihar. He doesn't want to go there. Now he is saying my transport.
Gopalpur is at the frontier, my lord. At the border.
I cannot argue.
Let him complete.
No, my lord. Now he doesn't want to. go.
Is it that he doesn't want to go or he seeks a year's extension? They are
He
different.
doesn't want to go. Now he says, now he comes to the HC, head constable has been transferred, not ASI. And his daughter is suffering from 2007, not right now. We have given you all extensions possible, my lord. But if you have filed a report, my lord may go to it.
Where is your report? You filed it earlier? A compliance, it's called a compliance affidavit.
Petitioner's daughter is suffering from 2007. He has been posted very.
Now, in this report, the report says nothing.
Nothing, my lord.
Where is it said that several considerations were made? He was given extensions. Where are those documents? Will you come back with a report?
We have it right now. We'll come back.
The petitioner has to be served, sir.
I will, sir.
You cannot bring out reports
No,
like
no,
this.
Ma'am,
in five
my lord, every time.
I will
Please
file
come
a
back
short-
with a report, a short report. Yes. Will you come back next week?
Yes, my lord. We'll finish this in this.
You can take this back. Please come back with a comprehensive report. Learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 9th.
My lord, exception to,
Exception of it.
my lord, new
Paragraph.
document they are bringing, my lord.
Paragraph on prayer of the petitioner, liberty is granted to use an exception to the said report, comma, if necessary. Taporé, let the matter appear under the same heading on.
On
9th.
9th, my lord. My lord, copy to be served.
Yes, obviously.
Yes,
Developed.
my.
What are they about?
Yes, madam, I am for the petition. My PR is only, my lord, to consider my representative. What's happened, my lord? The respondent number 5, that is additional executive officer, Kujibihar Jila Parishad, invited the tender, he tender. Subsequently, the
You are
petitioner.
appearing for all the respondents?
All the respondents, Kujibihar Jila.
You are appearing for Jila Parishad. State?
I. Yes.
I do not find the state councils, all of them have gone. State councils? Any state council present here? So.
Yeah.
Are they there or shall I grant an adjournment?
No. It was the. No. Madam, this is an application, my lord. The PR is, my lord, only, my lord, I submitted the work done, my lord, and my lord, I submitted the final page before the authority.
That was not released.
The daughter not released. I made a PR. My lord, kindly see my PR, my lord, on Annex P3. That has been.
Anyone from the state? This is a demand of justice. Where is your representation? So what does that mean? Advocate's prayer is demand of justice. Advocate doesn't pray. The court can direct disposal of a representation, not a demand of justice. So let 32 be considered. Yes. So let me do one thing. Since he has a representation pending before you, call him, tell him what needs to be done, consider the representation and pass an order. Yes, I was suggesting let the authority decide. I will not go into merits of the writ petition. Since a representation is there, let him approach, give him a hearing and decide. If the court decides, he loses a forum, isn't it? Mr. Shah, you are appearing. There is a representation, let it be decided. Yes, yes. Affidavit of. Let the representation be decided. Affidavit of service. the petitioner is aggrieved by the fact that though no, it is affidavit service for it. It is contended on behalf of the petitioner. It is contended on behalf of the petitioner that on the basis of a notice inviting tender issued by the additional executive officer, Kuch Bihar Jila Porishad on 23rd June 2022. And upon compliance of all formalities, work order was issued in favor of the petitioner. On 18th October 2022 for repairing of Pakka Road from Kashiabari, Kashiabari, Kashiabari Amtola passenger shed to Kashiabari railway station under Uttor Bara BARA, Holdibari, Uttor Para, Uttor Boro, Holdibari Gram Panchayat. Stop. After completion of the said work, the Jila Porishad issued a completion certificate in favor of the petitioner. Stop. The petitioner requested the authority for releasing the amount of the final bill in respect of the work done by the petitioner to the tune of rupees 23 lakhs, 2300,000, and submitted a representation in this regard before the authority on 8th May 2023. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondent numbers, learned counsel for respondent numbers 4 to 7 places reliance on a notice under section 79 within bracket 1, next bracket is C of the Central Act, State Act of the West Bengal Goods and Services Act, and submits that the concerned authority being the Assistant Commissioner of Revenue, Jalpaiguri, the letter is issued by the Assistant Commissioner of Revenue. It stated Jalpaiguri charged Jalpaiguri, that's all. Yes? Commercial Tax Department. ওটা বলুন Assistant Commissioner of Revenue, Commercial Tax Department, Jalpaiguri, requested the Jilla Parishad not to make any payment to the petitioner on the ground that an amount of rupees 64,78,167 is due and payable by him to the authority. Paragraph. Be that as it may, comma, since representation submitted by the petitioner is pending before the authority, comma, the writ petition is disposed of, directing the concerned authority being the respondent number. Yes? The Shabhadipati will consider. Additional executive officer, the additional executive officer, or the executive officer. Fourth, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner, dated such and such or dated either, within 2 weeks. Within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case and the concerned authority shall be at liberty to deal with the representation independently and without being influenced by any observation which may have been made in this order. Disposed of, rejecting. Next. Similar matter. It is the same petitioner in all the cases. Yes. I think there is no dispute with regard to these facts. 32. No dispute. The dispute is otherwise. You have asked for release of security deposit and earnest money. Your representation is at page 33. Let this be considered as the earlier order. I will not go into merits. You are appealing for the state? All those matters. It's a bunch of matters, yes. Please give the names. It is contended on behalf of the petitioner. Huh? Nahi, all that is not in dispute at all. The dispute is absolutely different in this matter. Since you have not paid the tax, there is a due. So let the representation be considered. I am not going into merits. it is contended on behalf of the petitioner that upon a notice inviting tender being issued by the additional executive officer, Kuch Bihar Jilla Parishad on 24th November 2021, and upon compliance with all formalities, work order was issued in favor of the work order was issued in favor of the petitioner on 29th December 2021 for construction of Pakka Road from Baganbari More to the house of Noor Islam at Gyandas, Gyandas -Roman 2 under Diwanganj Gram Panchayat. Stop. The work was completed within the stipulated time and completion certificate issued in favor of the petitioner on 6th July 2022. Stop. The petitioner prayed for refund of the security deposit and earnest money deposited by him, and also submitted a representation in this regard before the concerned authority on 8th May 2023, which has not been heeded to, HWDD, not been heeded to, which has not been heeded to. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents. Agir submission ta puro ekhane hobe. Agir matter je respondents submission ta বুঝতে পারছো ওটা পুরোটা এখানে হবে ওটা সেম সাবমিশন হবে কি আছে তারপর থেকে বলো সেম জিনিসটা বি দ্যাট অ্যাজ ইট মে বাকিটা সেম হবে ঠিক আছে পুরোটা হবে রেসপন্ডেন্টের সাবমিশনটাও হবে এখন না অ্যামাউন্টটা করে দিতে the amount of tax is also same because it's the same notification. Yes, same ওখান থেকে বাকিটা same matter. No, this is you are asking for release of earnest money. Agata same order. Just Agata 769 is so much to do work order at date time. ওই নোটিশ ইনভাইটিং টেন্ডারের ডেটটা হচ্ছে ডেট গুলো চেঞ্জ হবে তাহলে বুঝতে পারলি নোটিশ ইনভাইটিং ডেট 18th November 2021 আর ওয়ার্ক অর্ডার ডেট হচ্ছে 27th December 2021 for construction of Pakka Road from Pabna Colony Khalpara Road Telir More, TELIRMORE, to the house of Ashutosh Sarkar via house of Komal Sarkar under Dakshin Bada BARA, Holdibari Gram Panchayat. Bakita same. Yes. Security to the earnest money. Yes. Same order আগের মতন হ্যাঁ 6970 আর এটা সেম হচ্ছে notice inviting there's no date of notice inviting tender. Notice inviting tender date. Notice inviting tender date 6th April 2020. Work order. This is the date of work order 6th April 2020. Not the notice. Not ওটা notice inviting tender date নেই date দিতে হবে না খালি on the basis of notice বলেন যেটা বলা আছে work order 6th April 2020 for repairing of bituminous road small letter করে দিন from Diabari DIYABARI Chowpathi CHOWPATHI to Fakirpara towards the house of Bikash Burman via Chilajati Bazar CHILAJATI একটা শব্দ বাজার কমা ছাতির মোড় CHHATIR মোড় and Jigarsari JIGARSARI একটাই শব্দ under Hemkumari Gram Panchayat. Page 4 as similar. Yes, 72. Yes. This is also for refund of and security deposit. Earnest money security deposit will be maybe refunded upon subject to consideration, but yes. Where is your letter dated 27 February? Yes. There's reference to a letter dated 27 February 2023 by you. Because it is an amicable withdrawal. This is 23rd February, 27th February is your letter. of yes. Where is the document showing that you have purchased, you have spent, you have invested money? Where is the document? You say you have invested a huge amount of money pursuant to the work order. Where is that document? You want to take it back? I've recorded it. It is in some matter, I don't know. Let your representation be considered in that case. Yes. File a representation. Submit a comprehensive representation before the authority. Yes. That is an advocate's notice. I would request him to make a representation. Make a formal representation. I'll grant you liberty. Yes. Here also it is withheld for the same reason. Respondent submission to যেটুকু respondent submission সেটা সব matter same করবে। The learned counsel for the petitioner submits that pursuant to a notice inviting tender issued by the additional executive officer, Coach Bihar Jela Porishad on 23rd June 2022, and upon compliance of all formalities, work order was issued in favor of the two work orders were issued in favor of the petitioner on 23rd August 2022 for construction of Health and Wellness Center, centers at Chilahati More and Bosharajbala, BASARAJBALA, respectively. The petitioner incurred huge expenses for purchasing, construction and other material for the work but construction site SITE was not provided by the authority for long, LONG. For long, for which the petitioner was unable to commence construction work. Stop. The work orders were withdrawn / terminated by the authority by a letter issued on 28th March 2023. Stop. The security deposit and earnest money, as well as the expenses incurred by the petitioner for preparation of the construction, were not returned by the authority despite several requests made by the petitioner. Stop. The petitioner seeks to submit a comprehensive representation ventilating his grievance before the authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of respondent numbers 4 to 7 that বলে ওই রেসপন্ডেন্টের সাবমিশনটা দেবে যেটা সবগুলোতে আছে। Paragraph, be that as it may, since the petitioner seeks to submit a comprehensive representation, the submission for এটা দেবে seeks to submit a comprehensive representation before the concerned authority, comma, the writ petition is disposed of with liberty to the petitioner to submit such representation before the concerned authority within 7 days. Within 7 days from date. Stop. The concerned authority, being the fourth respondent herein, comma, is directed to consider and dispose of the representation within 2 weeks. Within 2 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, exactly. Next. Yes. It was withdrawn. Then it was withdrawn. You're asking for issue identification of construction site. Let him file a representation before you. It is submitted on behalf of the petitioner that pursuant to a notice inviting tender published by the Additional Executive Officer, comma, Cooch Behar Jila Parishad on 13th December 2022, and upon compliance with all formalities, comma, work order was issued in favor of the petitioner on 10th February 2023 for construction of new building wellness sub-center for HQ capital Hem Kumari within Holdibari Panchayat Samiti. Stop. Though the petitioner incurred huge expenses for purchasing material for the construction, comma, the actual construction site was not provided to the petitioner by the authority. Stop. The tender period lapsed in the meantime, and the petitioner was not in a position to commence construction work due to non-availability of construction site. Stop. The petitioner seeks to submit a comprehensive representation ventilating his grievance before the concerned authority. Several requests made by the seeks to several requests made by the petitioner for refund of the security deposit and earnest money, as well as the expenses incurred by him, made before the authority, were not heeded to. Therefore, the petitioner seeks to submit a comprehensive representation reflecting his grievance before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the correspondent numbers 2 to 6 submits, 4 to 7 submits. That bole correspondent submission. Paragraph. Since the petitioner seeks to submit a comprehensive representation before the concerned authority, comma, the writ petition is disposed of with liberty to the petitioner to submit such representation before the concerned authority, comma, being the fourth respondent herein, comma, within 7 days from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 2 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof, or it is made clear that this court has not gone to the merits of the case. We will enter into court ticket. The matter of shock merits disposed of which. This court is not going to the merits of the case. We will go to shock. There is one more similar matter.
Next. 74 I am for the petitioner. They only page 14. Construction work order. Work order.
Page
14, 1-4.
Yes.
Work order. Thereafter, page 15 is the tender.
What is your grievance?
Events is releasing the earnest money, same
Returning the earnest money. It is item number.
Item 70.
Please give the correct number.
70 plus.
No. In an earlier matter also a same order was passed.
Oh, earlier 73.
73 is expenses. Abhishek. Pursuant to a notice inviting tender issued by the additional executive officer, comma, Kuch Bihar Jila Parishad on 27 June 2022, and upon compliance with necessary formalities, comma, work order was issued in favor of the petitioner for construction of road from Poschim Jhakua, JHAKUA, Jhakua Para, Ramani Kanto Roy's house via Chandmohan Roy's house. Why all houses? Chandmohan Roy's house and Niren Roy's house under Uttor Boro Holdibari Gram Panchayat. Date number is 27 December 2022. 27 June আরেকটা তারপরে work order date বলিনি on 27 December 2022. Stop. The petitioner completed the construction work within the stipulated time frame and was issued. Where is your completion certificate?
No, but in your work order, the work has not been completed in a scheduled time. With that because the letter has been issued to the petitioner. In this matter, the same work order, actual site, work site does not provide.
You have not started the work at all.
Work site does not provide for that. I have not started the work order and the work yes.
Let me consider I'll consider the matter tomorrow.
And
Sure, okay.
Lord,
Come back tomorrow because this has to be dealt.
Lord, before my lord rises, Lord, may I make one request? Lord,
Yes. Not today.
Lord,
Abhishek, yes, tomorrow.
Lord,
I have to deal with the documents that you are showing.
Lord, if possible, my lord, may my lord give precedence to the hearing matters one day in the next week. If possible, my lord, if my lord may kindly considers.
I'll think over because with
Because-
the amount of motions that are pending, it is difficult. I'll think over.
Lord, my matter, there was some urgency I mentioned also yesterday, but I know your lordship is
If
not
we thought-
upgrading, lord. But if one
No,
day
if you
is
can show
not,
me one matter which is not urgent and is still
But if
pending,
some-
I'll upgrade your matter.
no, I'm not saying that, but one day if it could be given for hearing, lord, we could come on
We
that
don't
then
come
try
from
all.
stone in court, isn't it? We come due to urgency.
And, But
I'm
one
really
day. it
sorry.
could
I
be-
know I'm not being able to take up hearing matters.
No, I'm not
But
saying that,
there
but
are, there's a
one
load
day
of
it could
motions
be-
actually pending. So
now the
let me
circuit
see,
is,
let me
now
see.
circuit is continuing. So, lord, if one day could be allotted for hearing only, we can lord,
So
try
I
our luck
hear
on
half
that.
the matter and the other bench comes and hears the remaining
No,
half.
At least your lordship will be able to hear, not
There
whatever
are
matters my lord may
practical
able to.
difficulties, so let us consider. There
But
are
not
practical
hearing matters, then
difficulties.
not kindly do not take me otherwise, not then kindly consider our plight also. Not will not be able to, not earlier also we did
I
not get any
understand.
chance to get the hearing
I
matters. Now
understand.
since
Let me
the
see, let me think over.
kindly, lord, kindly consider this.
না, APDB